Yes, call the list. You want inclusion? Yes, call.
Item number 3. My lord, I am appearing, my lord.
Where is the impugned letter of 7th October?
Page 43.
Primary hypertension.
Yes, my
When was it detected for the first time?
In 2003 month. 15th of November 2003.
So merely because at the time of his enrollment, this disease was not there. That is the only reason. Is that sustainable?
The release medical board holding month.
80. Yes.
Reason, cause, specific condition, and period of service. The only reason for denying this, holding this disease as attributable or aggravated, not attributable or not aggravated, onset of the disability while serving in the peace. But nothing has been stated as to why, this will not be attributable or aggravated. The tribunal has taken a holding at
No, therefore,
internal page 7,
therefore,
14 and 16.
you are proceeding on the merit. What we are asking you is based on the admitted factual background that this disease, its onset was while you were in service. Does that in all cases means that it has to be held attributable to and aggravated by service? What is the rule position? Let us see. No,
It is a fact that in all cases it cannot be.
cannot be.
But primary hypertension, the nature of the disease is such that it is the first thing that will come to a serving soldier after serving for a reasonable time. So, my lord, this person was enrolled in 1995. He is an artillery soldier. His ordinary trade is that of musician, but a person does not play music all the whole time. My lord. He is a GD person, group general duty. My lord. He does all the duties of an artillery person.
All constables are JD.
Yeah.
It's not something.
Being a musician. So, my lord, he has been serving from 1995 till 2003, my lord, when this disease has been detected.
Where is the rule? Let us see the rule. 197. What is the rule?
Yeah, my lord.
My lord, only two lines I would like to reiterate, my lord, from the impugned order, my lord. The learned tribunal has held how the disease is not connected with military service. The board has failed to record cogent and possible reason.
Therefore, we are asking you, is it for the board to repel,
Yes,
dispel? So let us see the rule. That's what we are asking. You are unnecessarily harping on facts.
entitlement rules which
Therefore, we are saying come to the rule.
my lord is having the entitlement rules, my lord. It says that it is the responsibility of the
Let us see. See the rule. Yes, pension regulation.
not the pension, the entitlement rules, my lord.
Defense service regulations. Give the name of the rules on a piece of paper, please. Ask the librarian. Ask them to get it from the library. Ask someone to fetch it from the library.
Entitlement rules. 82. 82 now, 2018. 82 applicable.
State law. It is here. Those are acts. It is not like that. Can you read the provision, relevant provision? What is the relevant provision?
Searching. 2 minutes.
May I place to judgment, my lord?
Judgment, you don't want to read the rule.
That, my lord, rule 37, rely, my lord.
It has been quoted.
Quoted, my lord.
Then
Recent judgment of the Madras High Court, same facts, my lord. Primary hypertension. Journal page 4, my lord. Correct.
no, this is the correct. Why did you say no? This is the correct. This is the correct rule. Pension regulation of the army.
This forms a part of the pension regulation, my lord. It is one of the appendix, my lord. It is there in the appendix. It's a
So
separate-
disability element is 37.
37.
An officer who retires. Hmm.
The exact part is, my lord, of the entitlement rules 2008. It is rule 9, rule 7. It says onus of proof. Ordinarily, the claimant will not be called upon to prove the conditions of his entitlement. However, where the claim is preferred after 15 years of discharge, retirement or invalidment or release, by which time the service document of the claimant are destroyed after the prescribed retention period, the onus to prove the entitlement will lie upon the claimant. But in ordinary courts, my lord, it is upon the respondent, upon the
It is
writ
61.
petitioner here. No, no, 2008.
Which rule you are relying upon?
Well, I am relying on entitlement rules for casualty pensionary award to armed forces personnel 2008. Same provision was there in the previous rule, 1982 rule as well, my lord.
There is no change.
No, my lord. In regard to this, my lord, the number, paragraph number has been changed, but the thing remains the same.
Presumption changed to ordinary.
Well, not presumption. Who has to say upon whom the onus lies to prove? And that point was other two or
You are referring, we have got this entitlement rules for casualty pensionary awards. This is 82. Oh, this is not published.
82 is not
Not
applicable.
published.
2008 will be applicable.
It's not published because it is under revision. We
82
don't have it.
also has the same provision.
We don't have it. Show us.
Malad may kindly accommodate. 82.
You have it. You have that.
82,
No, it is
2000,
not applicable.
2008 का copy. आपके पास
2008
82 का
का।
है।
82 has been revised.
by yeah, it does have certain relevant page. Certain relevant page of my petition, my lord.
No, let us see the rule. What will you show from the petition? There is no dispute that he has suffered the illness. There is also no dispute that he was in service. Now, whether these facts can be taken to determine in his favor or there is something more, we have to see on the basis of the rules. Nine, you are relying upon 9. 7.
Unas of Dushman.
Yes.
My lord, this is regarding, my lord, in respect of the documents destroyed. Owner's proof lies upon the claimant, my lord.
Hmm.
Yet no documents destroyed, my lord. I am also relying judgment of Kerala High Court, my lord, on similar issue, my lord. Relevant para 18, my lord.
You are just throwing one judgment after the other. We are asking you to read the rule. What the rule says. Kerala High Court judgment, we'll see every judgment. But see what the rule says. That judgment you have shown us that judgment has not considered these entitlement rules. He is relying upon this. You have to get over this.
My lord, then, my lord, Rule 5,
Yes.
1982 rules,
So
and
82
read with
rule is not applicable.
2008 rules, my lord.
This is not 98. This is 2008 rules.
Yes, my lord. There is a comparing chart, my lord, here, my lord.
Why?
There is a difference between 1982 and 2008, my lord.
So that how that affects the.
There was a presumption at the time of entry in 1982 rules, but in 2008 there is no such presumption, my lord.
That issue we have already considered.
Yes, my lord.
We have passed a judgment on that issue. Yes. Where is that judgment? That is not the point. He's relying on this 7 of this entitlement rule 7, which says ordinarily claimant will not be called upon to prove the condition. Only if he is come belatedly, then he will be called upon to prove the presumption.
Then, my lord,
Otherwise, he is not required to prove.
then, my lord, I am referring the service condition of the respondent, my lord. Kindly see page 77 for a moment.
This was pertaining to injury. So it was different.
This was pertaining to injury, my lord.
Saurabh Biswas. This is the case.
This was pertaining to the injury, my lord.
He had suffered that while moving his.
No, we have considered the presumption aspect also. It was argued, perhaps in this case, it is the case, or any other case, we don't know. This is the case. 9 feet deep. This is the one. Yes.
There is no question of presumption, my lord. We are not going on the presumption, my lord. 1982 rule is not applicable, my lord.
At the time of his, he has completed his total period of
Yes,
engagement. Was he, at the time of his completion of his engagement, was he in a lower medical category?
At the time of engagement, he was not in lower medical category. In 2003, my lord.
At the time of his completion of terms of engagement, was he in a lower medical category? Have you stated that you were in a low medical
Yes,
category?
yes, that is the basic thing.
Where it shows the basic.
My lord, page 78 is the release medical board, my lord.
Yes.
Page 78, my lord. Remarks.
Yes.
My lord, the remarks from the lower part, my lord. Fit to be released in low medical classification S1, H1, A1, P2 permanent E1.
So what is the percentage?
Well, the percentage is there at the subsequent page 81, my lord.
Yes.
30%, my lord. Composite assessment for all disability with maximum duration 30%, my lord, for life.
At page 81.
81.
For disability, qualifying disability pension is nil.
30%, yes. And this is permanent.
Permanent, my lord.
But this casualty pensionary award will apply in case of disease.
For every, my lord, disease as well as injury, my lord.
Then why it says casualty?
That is the name the government has selected, my lord.
Can't be like that.
My lord, it is applicable for the diseases as well, my lord.
From where do we get this? Show us from where do we get this? Yes. Yes, come to 10B. This one. Next. Here also, it's a clause 3. 10B3. So this judgment has not considered this entitlement to rules, this rules of 2008. Entitlement rules for casualty pensionary awards. Entitlement rules has not been considered. Which other judgment you are relying upon? Show us.
My lord, हाईकोर्ट को भी 18 नंबर तो ये हम लोग
if my lord may only for one instance read paragraph 16 of the impugned order, my lord. May I read out, my lord?
Let him, you will get your chance. Why are you impatient?
এই দিলাম তো, এই দিলাম তো।
With judgment?
My lord, kindly see page 77, my lord, before of my petition, my lord. For a moment, my lord.
Yes.
Part 1,
Yes.
details of service, my lord,
Yes.
of the respondent from 14th August to 2001
Yes.
till date. In he was in peace area, my lord.
Yes.
In support of my this, my lord, I am relying on the judgment of the Madras High Court, para 12, my lord, which I have already handed over, my lord.
Yes.
Entire input judgment passed on the basis of Dharambir Singh case, my lord, which is not applicable. Kindly see para 12 of my Madras High Court judgment, my lord. It is a complete parallel case, my lord. Para 12.
Where does it say peace? Oh, this is peace. This is peace. Para?
Para 12. Internal page 8, my lord. Judgment.
Before the apex court.
No, my lord. Nobody has challenged, my lord. As per instruction.
You know.
As per instruction, this is
April. Yes.
thereafter, my lord, come impugned order page 107, my lord.
Which paragraph?
Paragraph 15, my lord. The present rather is a case squarely covered in favor of the applicant by receipt of the judgment of the Honorable Apex Court Dharambir Singh case. It is not applicable, my lord. Madras High Court also held this, my lord.
It is not applicable.
Not applicable.
Why?
Because it relates to 1961 and 82, and the petitioner was from service in 2019, my lord.
So therefore, we are referring to the provisions which are in vogue right now. We are not referring to any provision.
Medical guidelines, there is a medical guidelines whether applicable or not, my lord.
What is applicable or not?
Which disease is applicable or not? There are some medical guidelines, my lord.
So
Hypertension.
what do you want to say? Before you give it to us, tell us what do you want to say.
In respect of hypertension, my lord,
Yes.
the first consideration should be to determine whether the hypertension is a primary or secondary. If secondary, entitlement consideration should be directed to the underlying disease process, and it is unnecessary to notify the hypertension separately. As in the case of atherosclerosis, entitlement attributability is never appropriate, but where disablement for essential hypertension appears to have arisen or become worse in service, the question whether service compulsion have caused aggravation must be considered. However, in certain cases, the disease has been reported after long and frequent spells of service in field and high altitude area. Here the petitioner responded in peace.
You are reading something about secondary hypertension.
Both.
The issues of
It gives all primary and secondary both, my lord.
so secondary, I have to give it to him. In case of primary, we don't have only one.
You have only one copy.
One copy, my lord.
Page কত বলেছে?
If it is occurs while serving field area, right?
Page number 77. It deals with the primary health.
This is regarding aggravation. This is not regarding attributability. This is not regarding attribute. This is not regarding attributability. This is regarding aggravation of disease.
Last two line, my lord. Hypertension will be considered if it is occurs while serving in field areas, high altitude area.
We don't know how to read this. This is chapter 6 of which book? It is in what context? We don't know. It is talking about aggravation. Second page of
Intended to
Has been
general
brought in.
guide for assessment.
It's an administrative guideline, my lord, prescribed by the higher medical authorities of the army, so that these
Dispose of their cases in basis of this finding guideline. previous one. That it has to be. Sir is serving at a high altitude. The field area then has to combat with tension service. Not only the
This is, yeah.
No, not all along. Not
Five
all
and a
along.
half years in field area.
He was in a field area from 1st February 96 to August 2001.
But he's
5 years. Just prior to this posting. This does not say anything about primary hypertension.
services says
What does it say about primary? Read. It says the first consideration should be to determine whether the hypertension is primary or secondary. If secondary, then it says such and such has to be done, and then it goes on. In the last, it says primary hypertension will be considered aggravated if it occurs while serving in field area. So it's not a case, we are not looking at aggravation, it's onset. Attributability is what we are examining. There are two elements, attributability and aggravation. It does not say anything about attribution because this is a guide for the medical board which will examine this person. The medical board has not taken into consideration anything from this. We don't find anything, any reference to this also.
this disease was detected.
Three.
In 2003, when he contracted this, or when at the time of onset of this disease, there was no board. For the first time, this board is being done at the time of his release.
But the board is there at page 45, my lord. The initial medical board.
Viral type.
2003 board, my lord. Lord, paragraph 7 of which says, was the disability contracted in service? Yes. Was it contracted in circumstances under which he had no control? Yes.
Thereafter, madam, is the disability attributed to service? No.
Page number
45.
Lord, the next paragraph, if not directly attributable to service, what is aggravated by service? It says no, but says no, it's illegible, my lord.
Clear.
No history of exposure to stress in field posting, high altitude or CI ops in the last 6 years, which is absolutely incorrect, my lord.
Yes, that is incorrect.
That was
Not
the reason
attributable to
given for
service.
holding it as not attributable, not aggravated. But immediately prior to
Till
that, my lord,
2001, he was in the field area.
yes.
So how they have said that there is no What is CI ops? Counterinsurgency.
Counterinsurgency and operational area.
Well, musician methods. Page 45, column 20, my lord. I am relying, my lord.
Hmm. Last 6 years. Why it is taking into consideration last 6 years? This is wrong. So high altitude and counterinsurgency, these are the only two circumstances.
Yes, my lord. Kindly see page 45, column 20, my lord.
Column.
Column 20, my lord.
That is what we are referring to. You say that no history of exposure to stress, etc. What do you say? No exposure to stress. For example, field posting, HAA, CI ops. This is wrong. This is wrong. He has been in field posting till 2 years prior to this assessment. He has been in the field till 2001. How you are saying for the last 6 years he has not?
But that was not the high altitude area, my lord.
Not required. If that was if field area was not relevant, you would not say. You have said here field posting. Now you want to confine it to only high altitude. In appropriate case, you will say counterinsurgency also is not applicable. Very surprising. Every case where disability pension is given, you come to the High Court. Every case we are finding. First, you make a rule, the government makes a rule, and then, as per the rule, when it is granted, you come to the High Court. Before High Court, you never relent. Must be a found only one case. So forget about Dharamveer Singh case. We are looking at these things. We are not on Dharamveer Singh. This is the wrong assessment basis. Assessment basis is wrong. It's not sustainable. This finding is not sustainable. And Kerala judgment, what are you relying upon? Let's see. That is the only thing now which remains.
Last High Court judgment and Kerala.
Madras you have already placed. Kerala you have not placed. You are relying on the table.
Next question, respect of the disease, my lord.
Yes, we have seen that. Rule 14.
Rule 10, my lord. Earlier, my lord, 14.
Yes, now it is 10B.
For the acceptance of disease as attributable to military service, the following two conditions must be satisfied. That the disease has arisen during the period of military service, that the disease has been caused by the conditions of employment in military service.
And the Madras High Court has not considered the entitlement rules. Is there any reference to the entitlement rules in Madras High Court judgment? I don't think so.
My lord, is 5 of Madras High Court.
Yes.
Paragraph 8, my lord.
Yes.
They stated sort of primary hypertension.
No, we are asking you a specific query. Has it considered the entitlement rules?
Only rule 37,
That's page
page
No.
4, my lord.
2008 entitlement rules, has it been considered?
I'm no, 37.
NB. Yes. Huh. Sorry. Kerala High Court, what is the result of the case?
Incentives.
So Kerala High Court, you are only relying upon this table. Judgment is not required. The 2008 rules is before us. Kerala High Court, the tribunal had relied upon Dharmveer Singh in the Kerala High Court judgment.
Yes, my lord. No. Only Madras High Court.
So therefore, Kerala High Court judgment is not relevant for us. 2008 rules we are going to consider anyway. Is like this. It's here they say for first instance, this is what they say in 20. This is
Kerala High
47.
Court, my lord, para 39, Dharamveer Singh case was referred, my lord.
For voting. What is the difference? There were two victims, one contained in the 57. Disability element may be granted 20%. If the disability is accepted at 20% only, here it is 30%. So as per this, we will like disability element, but provided that attributable or aggravated by me. So therefore, we have to see whether it is attributed to service or not. How it is to be seen. For that, this entitlement has been 2008. 2008 says that ordinarily the claimant will not be called upon to prove the condition of entitlement unless it is late. Is that late? Then not in every case. Then we move on to discuss diseases. Only if two conditions have to be satisfied that they have occurred during military service and caused by condition of employment in military service. Okay. And if nothing is applying here, because if nothing at all is known about the cause of it, and the presumption of employment is not repeated to be considered. The third thing to be considered is we already seen these are not considered for entitlement. Para 59.
Para 15.
Kerala High Court, you are saying para 59. 49. Which paragraph you just said? Dharamveer Singh has been referred.
Para 39. Dharamveer Singh case was referred, my lord. And there was a case of invalidated from service.
But this judgment is only of 53 paragraph. How you are referring to para 59?
Para 39.
39.
39.
So why this will not apply?
My lord, this in Dharamveer Singh case,
It was under the 82 rules.
82. Second,
Yes.
there to the
Same paragraph,
in
second
same paragraph, my lord, we have referred the medical guideline that has been referred in this, my lord.
The medical guidelines, it was required to be considered by the board. It has not been considered by the board. On a wrong consideration, you see page 45 at clause 20. That is wrong. How the board has proceeded on a erroneous presumption that in the last 6 years he has not been posted in the field. He was in the field just till 2 years back. How it has?
First time detected in 2003, my lord.
Hmm?
First time hypertension was detected in 2003, my lord.
That is why we are saying.
Peace area.
That is why we are saying till 2 years back he was in field area. He was in field area till 2001.
Yes, my lord.
So this finding of the board, this is the basis on which it is not being considered attributable to service. This basis is wrong. How it can be relied upon? This is factually incorrect on the face of it. It's a perverse finding. Very well. Yes, take down.
4.
Lord-
This matter on the last occasion of the respondent took time.
Lordship,
Found that he was newly briefed in the matter, that's why he sought for time. Your Lordship granted the one-day time. And now the matter, your Lordship hard on the day before yesterday. But they are only working for 5 months. And on the re-examination, it was found he is suffering from tremors. Thereafter, he has been
Oh yes, that tremors one. Yes.
Lordship, my senior is not well today, Lordship. Kindly accommodate for 1 week at least.
Not today.
Not this week, my lieutenant.
Not today. Let's
1 week.
No 1 week. We had requested the prayer for 1 week. Not today. Ask her to be here, or somebody should appear tomorrow. This is not.
On the last occasion, they also said,
Huh?
then will give some time more, because he's saying that she's suffering from.
Yeah, she is
Otherwise,
bedridden,
he can
Lordship.
make a prayer
Or she
before
would have
Lordship.
come today, Lordship. That's why I'm praying for, like, at least
I'm
2
making
days.
last chance, my lord.
As prayed by the respondent list after 1 week.
Lordship.
5.
Mr. Afrozul Haq is appearing for the private. He is also suffering from fever. Kindly make it not this week.
As the matter was also adjourned, he has come.
He has come.
Yesterday he has come. No, my junior was there. Activity due to his non-appear.
You are opposing prayer on the ground of illness.
I'm not due to his
You are, sir.
fever. I am not opposing.
Then you are. You just said that why he is making a mentioning. What happened? How much time he needs?
Not this week only.
Monday, Tuesday, what is convenient for you? As prayed lists on as yes, affidavit of service is taken on record. You give.
6.
See, I've got the petition.
The highway affidavit of service.
We heard this matter.
Yes, already heard
That
this
proceeding matter.
disciplinary proceedings and set aside and quash the entire things by the tribunal. And we have been directed to proceed de novo from the disciplinary office.
So why don't you avail the liberty granted?
But the only thing, will not kindly record my submissions. We are not accepting the tribunal's order. As if it is followed from your lordship's points and
All right. We have understood.
my
Yes.
contention is number one. This order passed by the tribunal is contrary to rule CCS rule 10 sub rule 4. That was the first ground to challenge this order.
Yes.
Second, the few observations as made by, there are certain observations made by the tribunal. But my humble submission, tribunal supplant some causes, it was not the case before the disciplinary authority. Like the inquiry officer did not proceed with or assumed as a criminal proceedings, not initiated a criminal proceedings, etc.
Yes, that is a unique finding.
Right. That is in findings of the tribunal because that was no such charges.
No, that is a unique finding. I have never seen such a finding that this has to be made a criminal offense and it cannot be made as. I don't know if there is any other such judgment like this. But
That is my humble submission. The tribunal supplant some point which was not been made out by the even the delinquent employee.
no, but that ipso facto will not help you. Even if it goes, even if that observation is gone, the tribunal's order otherwise also is against you. That's not the only ground.
These are two grounds for I have taken before your lordship. Kindly record my submissions and according to my lord may pass an order.
(10-4). Why 10-4?
10-4 because let me finish, sir. why I'm relying on 10-4 is the tribunal, after hearing the party and made certain observations for it, was pleased to set aside the entire disciplinary proceeding and demanded back to the disciplinary authority to initiate de novo proceedings. Here, my lord, when the de novo proceedings would have been warranted, but that is 10-4 proviso says so. 10-4, kindly consider 10-4 proviso, providing that such further inquiry shall be ordered unless it is intended to meet a situation where the court has passed an order purely on technical grounds without going into the merits of the case. My humble submission, the tribunal has gone into the merit of the case, made certain observations, came into their findings, and supplied some points and grounds also, while setting aside or quashing up all the interdisciplinary proceedings.
No, this further does not mean de novo. When you are reading 10-4 proviso, it refers to further.
Further.
This does not mean de novo. This is for further.
Further means my interpretation.
Further means that if there is a deficiency, for example, somebody has been examined, not cross-examined, some witness who was there could not be examined. That means further. De novo means starting afresh. So therefore, 10-4 does
from
not.
the stage where
Yeah.
it was technically found wrong. From that stage, it could have been initiated.
Anyway, that is your submission. This
My
will not apply because the tribunal has not set aside on basis of any technical.
My humble submissions for it, I appreciate your lordship, has gone into the merit and made his findings.
And why the charge sheet has been set aside?
Charge sheet has been also been set aside. But that
Yes, how do you sustain setting aside of the charge sheet? Huh? Where is the finding of the tribunal that charges is not specific? In which paragraph? Show us. There is no such finding. You have not made argument on this.
I did make some,
Huh?
not even before the trial.
Regarding charge memo, you have not made any argument.
Regarding charges, since it has been set aside as a whole, that disciplinary proceedings has gone. I can't say when tribunal was. My humble submissions on rather when the entire order has been erroneous order has been passed.
No, but it is in three parts. One is that it has found that the inquiry officer has not proceeded as was required.
Right.
Other is that the charges do not constitute an allegation which can be part of a charge memo in a disciplinary proceeding. It can only be an allegation in a criminal trial. On this aspect, you have not made any submission.
But right now, I don't want to make submissions further because if I make submissions, I will make these submissions. But if your lordship ultimately is falling from your lordship's minds were to uphold the decisions of the tribunal.
No, those are prima facie. If it had to be done, we would have done it on the last day. Nothing stopped us from doing it on the last day. But
charges, then my responsible submissions, charges were rightly framed.
So on that aspect, you have not made any submission.
Kindly see
He is saying that there is not specific. If I remember correctly, there is no such finding of the tribunal. That the charge is not specific.
Kindly come to the charges. All charge sheet has been framed properly.
Yes.
But article of
There is such a finding that it is.
no internal page 3 of this.
Let us see what he is saying. Page Yes. Sir, we asked you a specific query. You said that it was not a specific charge. We asked you where the tribunal has said charge is not a specific. You are rating charge is vitiated. You said it is there, and now you are not showing it. We didn't ask you whether it is vitiated. We made a specific query. You said that the tribunal has held charge not sustainable because it is not a specific charge. Charges are vague. Now we asked you to show where is that finding. Either there is a finding or there is no finding. You should not read something else. As per the memory which I am relying upon today, I could not find it. That we didn't ask you. Saying vitiated does not make it vitiated. It has to be vitiated on some basis. Yes. So that we have seen. He has said that it should be a criminal case.
Only one point.
That is all he has said. That they have said it's a DB order.
Journal page 3, there are 4 article of charges has been set out.
Yes.
Internal page 3 of the judgments.
Yes.
So there are article of charges 1, Mr. So and so, ticket number of Contempt Factory, Kashipur, Kolkata, who is charged with gross misconduct of illegally making money by giving false assurance of the government job in Contempt Factory, Kashipur, to the outsider and tarnishing the image of the factory management. Thus, the said Sri Gorai has indulged himself in an act of gross injustice and a conduct of unbecoming a government servant in violation of Rule 3.1 of the Central CCA Rule 1964. Article of charges 2, see so and so, the skill level so and so, ticket number such and such, gun and self factory, Kashipur, Kolkata 2 is charged with gross misconduct of unauthorizedly possessing rubber stamps and doctors and headmasters and misusing them with malafide intention for his personal gain. Thus, the said Sri Gorai has indulged himself into an act of gross indiscipline and a conduct unbecoming a government servant in violation of Rule 3 of CCA Rule. Article 3. He so and so is charged with the gross misconduct of fraudulently misusing call letters for pre-employment medical examination using pseudonomous names and signature and malafide intention for his personal gain. Thus, the said Sri Gorai has indulged himself into an act of gross indiscipline and a conduct unbecoming of a government servant in violation of Rule 313 of CCS rules. 4. So and so charged in gun and cell factory, Kashipur, Kolkata is charged with gross misconduct of unauthorizedly possessing 2 years come smart identity cards and gun and cell factory, Kashipur, with malafide intention for his personal gain. Thus, the said Sri Gorai has indulged himself into an act of gross indiscipline and a conduct of unbecoming of a government servant in violation of Rule 1M of CCS. These are the article of charge.
13A, para 13A is the only finding.
A, my humble submission. 13A, on the last occasion I have made my submission before Lordship. This is pertaining to the findings pertaining to that criminal case, why it had not been initiated. Because under PC Act could have been, under IPC could have been registered an FIR on the basis of that. So, my humble submission, this was not the case before the
No, the tribunal has said it is beyond the competence of an inquiry officer in a departmental inquiry to prove this charge.
Yes.
How he is beyond competence, we don't know.
My humble submission, the law is well settled here. The department can also proceed departmental.
Yes, for every charge there can be a parallel proceeding.
Parallel proceedings can be continued.
In some cases, it is said that the department will await conclusion of the criminal trial. In most cases, it is not accepted that they may proceed parallelly also. These are settled propositions of.
Parallelly, we can proceed. So my humble submissions, the proceeding with departmentally against the delinquent employee, against the government servant was absolutely correct based on the memorandum of charges. Inquiry proceedings was held.
Hmm? B. No, B is not about the charge memo. We are only about the charge memo, asking you about charge. We have seen B, not that we have not seen B. How the charge memo has been quashed, that is what we are trying to ascertain. Because the inquiry officer is not competent to conduct the inquiry. Why? There's nothing in the order. Hmm. Just give a judgment. The grounds on which a charge memo can be interfered with. You have any citation? There are so many cases. Can you give us?
Tomorrow one can.
Yes, for list for further consideration. You may be. What do you want? Can you please use the mic, sir? No, your OA is there. What application? What application? Your OA is there. What application you will make whatever submission you want. We are not stopping you. We have to confine to the records before the tribunal. This is not the place for filing anything.
The fact remains that they have, the Honorable Tribunal has accepted that there no charge has been sustained against me.
So tomorrow reserve your energy. Yes.
Item 7.
Charge memo.
One indulgence, my lord. I did not receive the hard copy of the petition from my junior, my lord. Kindly fix it next week. Next
So,
week.
my lord, only one thing, my lord, next week I may not be available, my lord. If it
All right.
take-
As prayed by the as jointly prayed list. AFT matter.
Item 8.
Next case. As prayed list after 1 week.
সেম অর্ডার তো 30 করবো এটা কত গুণ হ্যাঁ
They know WPSC is coming up. Cities. These are normally 220. These are normally just or 20. Not really. Call the next. After 1 week.
Item 9.
Monica Roy is appearing for the respondent applicant here. She is not well and
As prayed by respondent 1 week.
grateful lordship.
Item 10.
Yes, my lord, I am waiting, my lord.
Service is complete. It is one of those cases.
But there are some differences, my lord. In this case, my lord, case was filed on 26th August 2021. Order passed on 3rd September 2029. We have passed the speaking order, but they did not challenge the same, and contempt was issued, my lord.
Both in compliance of this order, you have passed the order. What is the date of the order that you have passed?
March 2022 at page 167.
157, my lord.
For including that allowance, something there, what, including what allowance?
Contemporary allowance overtime.
Overtime to be included in the
Contemporary HRA.
contempt. But you have not placed this order 23, 22.
167, my lord. We have placed, my
No, no, before the tribunal, if it has issued a contempt rule, why you will not show the tribunal that you have passed the order? Why have you come here?
They have received the order, my lord. 229, my lord. Can you see?
Huh?
Page 229.
No, no. See, there is an order which you have challenged. It is of 22/4/25. In that order, we do not find any reference that you have produced this order before the tribunal. Why you should not produce it before the tribunal?
In fact, my lord, no, this was not the, but it was served upon the respondent, my lord.
Wonderful. Then why are you here? Unwanted litigation. Unnecessarily you are here. If you have complied with the order, you have to show compliance. You have served on respondent. That is all. The tribunal means nothing to you. You go and tell the tribunal that has been complied. Yes.
In the meantime, my lord,
See, we are the last person to do this.
at least some protection for the,
What protection?
for the personal appearance, my lord.
What has been done? Where is the direction?
Personal appearance direction, my lord.
You want an order in the nature of anticipatory bail? What is this? There is nothing. This should not have been filed. Yes, take down. Heard Learned Counsel for the
11 to the same line.
No, no, different.
And number 11.
It is similar to earlier 4 matters, my lord. Yes, ma'am. They have given the under acknowledgement, my lord.
Ask him to be here. 1 to 6. Give. You have a copy of the order we have been passing.
Yes, my lord. This one is.
What facts?
IP comes to the order passed by the tribunal.
Have you seen that order? Which? No. Give him a copy. This order. Then what do you want to submit? Why comes to what is wrong with that order that we are passing?
Over here, para number 6, which have been modified to that extent, Your Lordship, by your Lordships.
We are asking you what is the distinction in your case. Don't show us the entire thing which we have already seen.
Your Lordship, but I just need to place a few things.
Or what? What do you want? You don't want that order to be passed in your case.
Extension of time, Your Lordship, but setting aside of paragraph number.
So, all right, then you contest on merits. Let's see. Now, how do you have jurisdiction to file the application in Kolkata? Tell us. Come to the jurisdiction aspect first. Who are the respondents? No. Who were the respondents before the tribunal? How you filed an application in Kolkata? Come to the Administrative Tribunals Act and rules. What is the procedure regarding jurisdiction? Let us see. Who are the respondents before the tribunal?
Union of India Service Secretary, Ministry of Defence.
Yes.
The General of Defence Accounts, Ministry of Defence having office at Delhi.
Yes.
The Director General of Ordnance Factory and the Chairman.
Yes.
Factory Code, Government of India, Ministry of Defence, office at Calcutta.
Yes.
Principal Controller of Accounts, Ministry of Defence having her office at 10A, Shohid Khudiram Bose Road, Calcutta.
Yes.
General Manager, Uttar Pradesh.
And you are the employees of which organization?
We are all from Kanpur. Kanpur and Pune.
You are from Kanpur. Therefore, being employees of organization in Kanpur and Pune, can you file an application in Calcutta? Let us see. Come to the jurisdiction aspect.
Over here, the main answering respondents over here are.
Sir, please refer to the provisions in the tribunal. We are not on facts. We are on jurisdiction. Come to the jurisdiction. Come to it, yes. Come to the Central Administrative Tribunal Procedural Rules 87, Rule 6. Read it, what it says.
Administrative tribunal rules. Rule 6.
Application shall ordinarily be filed by an applicant with the registrar of the bench within whose jurisdiction the applicant is posted for the time being, or the cause of action wholly or in part as arising.
So where were you posted? So what part of the cause of action has arisen in the jurisdiction of Kolkata?
We are posted in the practice.
That you have said. So either you have to be posted within this jurisdiction, or the cause of action in whole or in part has to arise. So what part of the cause of action has arisen here? Tell us.
The umbrella body at that relevant point of time was the OSB, my lords. So OSB was having headquarter at
You have read the provision. You cannot just escape the provision and make any submission. You are appearing to assess the court. You are here to throw some light on why your client has filed the case there and how it is sustainable under the rule. You have just read the rule. What is the requirement under the rule? Tell us. Where the factory is there. Or there are two circumstances. You are not posted in Calcutta. None of you. So that is not there. Therefore, we are asking you what part of cause of action has arisen in West Bengal. Tell us. Don't say umbrella and this organization and that organization. That is not relevant. The rule says just two things. Either you are to be posted within the jurisdiction of the tribunal, or a cause of action in whole or in part has arisen. From your OA, show us what part of the cause of action arose within the jurisdiction of West Bengal. Show us that in the issue is over.
Pleadings नहीं होते. Sure. No such pleadings.
Come prepared, not today. Go through the way. Don't waste time. If you have something to say it on merit. Don't just make any submission without any meaning. Yes. Next case.
May I one interjudgment? Kindly pass an order, my lord, please to hear this application and adjourn for one sentence.
On prayer of the learned counsel. Item 12.
For a short pass over, my lord.
Why?
On another court engagement.
We will come. Let us see what it is. What is the issue?
She filed an application for voluntary retirement, but she has not appeared before the medical board and absenting duties for a long time. Then medical board was constituted. Medical board appointed that medically fit, and that she said
Supplementary was to be filed. That has been filed. Supplementary has already been filed. Yes.
affidavit করে বলেছে এটা
সাপ্লিমেন্টারি
আমাদের
তারপরে আমাদের এটা কারেন্ট দিয়ে গেছে এই তিনটে দিতে দিয়ে দাও একটা
করতে হবে।
এটা প্রেজেন্ট
বাবু, ওটা ধরে হয়ে কোনটা দেবো? And on 12 June, I have received a latest development.
What is it?
দিয়েছিল
Firstly, Dolly Bhattacharya, director resumed duty by the Block Medical Officer Health, Domjur Hospital, Howrah Bhait memo dated 20th August 24, refers to the matter issued by the director. Dolly Bhattacharya joined her duty after a long authorized absence from 16th August 2011 to 23rd August 2024 at Domjur Rural Hospital, Domjur, Howrah.
13 years.
As per medical board, medical college hospital, the petitioner is fit for further service with less laborious character that now she has been doing as per when the petitioner directed not Kibra Diara, but he is not attending the duties.
13 years. Absence is 13 years.
Continuous. From 16th August 11 to 2024. We want to initiate proceedings. I ask the department not to please stay your hand so that matter is pending before this matter. And public is suffering. And we are taking steps for regularization of the leave.
Why you are so slow?
No, madam, normally do not dispense with the service of a doctor because a public service, public will be benefited.
Somebody who is not working for 13 years.
They wanted to initiate a department proceedings for an unauthorized substance. I've requested them not to steps at this stage because my lord is seizing of the matter. As soon as the matter is we are issuing letter after another, but she is not attending the duties. Good. পেজ করে কে করবে পেজ করে যেত না কোন থেকে করা যাবে কমিটি
Mr. Sudhir Parker advertisement on the no, madam. And he's only good for my justice. So, for another. I'll make it short possible. I'll make it short possible. Or fix the matter on 2 p.m. madam.
More than 12 years she was absent. We could have terminated her service by issuing different proceedings. Because matter was pending before the Supreme Court, I have asked the department, please stay your hands. এটা পেজ মার্ক করা যেত না এইটা পেজ মার্ক করে ওরকম ভাবে আমি কি করে পড়বো কি আরে বাবা একটা কপি দুটো কপি থেকে বাজে কথা করেছিল And show cause notice has been issued to take steps on 20th August 2024. The page mark টা কোথায় তোমার 5 members in the medical board was there. The members opined that she is fit for further service of less laborious character than when she had been doing.
Where is the order? Where is the medical board?
Kindly see last order dated, a report dated 21st June 2023 in the bunch of papers. Right hand side, marking page is 43.
Have you given a copy of this bunch of papers?
My lord, one,
This was not before the tribunal.
because your lordship wanted to know what is the latest development. That's why I obtained this from the department.
So where is the medical board?
Medical board here. Can you see the medical board? Medical board dated 21st June 2023.
Yes, medical report.
Page 43. The expert meeting of the medical board was examined Srimati Dolly Bhattacharya, HAF, on 25th May 2023 at 12:30 p.m. and advised to undergo various report and the consult cardiologist and endocrinologist, preferably from the government hospital. They said reports were submitted on 19th January. The members opined that she is fit for further duty, less laborious character than when she had been.
This has been served on her.
Yes. Can you see bottom? Dolly Bhattacharya signed. Five doctors were present in the board. Head of the department, orthopedics. Head of the department, all. And show cause notice was also issued for initiating different proceedings.
Yes, we are looking at the show cause for initiation proceedings.
Because she was asked to report duties.
But that is not in this bunch.
Yes, that is the first page, 20th August 2024. He was requested to resume duties within 7 days.
What happened after that?
After that, we are
Because this matter is pending.
Department phone me, contacted me whether we can complete the department proceedings or terminate our service or not. Let us wait since Honorable High Court is decision of the matter.
Now that show cause has been issued, how VRS can be granted? Cannot be granted. Once show cause has been issued, where is the question of VRS now?
No. When show cause notice issued, VRS, no. The department by initially terminator wants to terminate the service, but kindly do not do that because matter is pending before the Honorable High Court.
Yes. How you can challenge a medical report in the tribunal? How the tribunal can look into a medical report? Yes, how the tribunal can look into a medical report?
I am extremely sorry, my lord. I was.
No, it's all right. How the tribunal can look into a medical report? Opinion of a medical board of 5 doctors, how the tribunal can review that board?
Medical board, my lord, also opine. My lord, at present, what is my grievance? My lord, the medical board has already opined that she is fit for further service of less laborious character job. My lord, at present, I joined in the service. My lord, that I corroborated in my supplementary affidavit.
Not required. See, the case before the tribunal was that you have applied for VRS They are not conducting medical board. You wanted direction to conduct medical board. Medical board has already been conducted. They have found you fit. Now, whatever you want to do, you can do. With nothing remains. From the tribunal's order now, nothing remains.
My lord, from the learned tribunals, my lord,
What is your prayer in the OA? Come to the OA.
my prayer is, my lord, kindly see.
Yes, we have seen, therefore we are asking you to set aside the medical report. How a medical report can be set aside by the tribunal? Therefore we asked you.
My lord, and to allow your applicant to retire voluntarily.
So which cannot be done unless the medical report is set aside. So medical report cannot be challenged in the tribunal.
Page 51 prayer. Page 51 prayer.
Huh?
The original application. Page 51 prayer in the original application.
Yes, that is from where, that is why we have asked him how a medical report can be challenged before the tribunal.
What is the medical report?
It is a report. It was, we don't know if there is any appeal provided against a medical report or what is the situation. How it can be.
Voluntary retirement.
And now there is already a show cause. Where is the question of voluntary retirement? Cannot be done.
My lord, at present, I joined in the service, my lord.
You have done the state a big favor. The state of West Bengal, you have done a big favor that after 13 years of unauthorized absence, you have joined.
My lord, I seek, my lord, voluntary retirement since.
And then you want voluntary retirement immediately.
In the year 2009.
We are not concerned. The medical report is not permitting you to get a VRS. That is the factual position. Which medical report you have challenged in the OA?
Page 43.
In the OA, which medical report you have challenged? Page 43. How this can be challenged in the OA, sir? He has not, in the prayer, he has not mentioned which report he has challenged. We don't know, therefore we are asking him. Which report he has challenged? This OA is of which year?
Year of annexes. 2020. I find page 4, internal page 4 of the
45.
way.
Way number 11 of 33.
Yes. What is the ground for challenging the medical report? Tell us.
I prayed for, my lord, voluntary retirement, my lord.
Sir, we are asking you what is the ground for challenging the medical report? Unless medical report is set aside, can you get VRS? So we are repeatedly asking you what is the ground for challenging the medical report? The tribunal has allowed you to pursue your, you pursue it. What can be done? Yes, take down.
Order, I give number 1 and 2.
Let's say, get out. Yesterday also, I find 2 matters continued up to 4:30.
Too early for me to say that. I don't.
Item number 2.
And 33 also.
Let us see. What can I say right now? How long? Today?
Taking up the original side first.
Yes, so it is.
So, my lord, then, my lord, I should, my lord, be through by, my lord, 3:30, my lord. I'll conclude my submissions.
Then, my lord, kindly give me some time, my lord, to respond to it.
So today we will not be.
I would, my lord, pray.
You don't want today.
No, after Mr. Mukherjee.
You will continue.
আজকে করবে তো তুমি I'll conclude today.
Let us see. I don't want to release everyone right now. Let us see. 3:30 we can. Although we don't. Pointless, then we'll release everybody else. It will come as it is. It will. We don't know. Tomorrow we'll see tomorrow. Yes. Meeting. Where's the memorandum? Memorandum. Yes.
Yes, my lord, may I, my lord, straight away, my lord, start from where, my lord, I believe, my lord, left off, my lord, on the last occasion. My lord,
Yes.
if your lordships kindly take, my lord, volume 18, my lord, of the paper book. My lord, I believe the last document, my lord, I had started showing to your lordship, my lord, was, my lord, page 575.
Yes. 570. We had gone to 585. But
Correct. Now,
yes.
my lord, I was at page 585.
Yes.
Now, my lord, kindly have a look at, my lord, page 585, which is, my lord, part of the policy, my lord, which was, my lord, applicable. Kindly come to, my lord, clause 24. My lord, it says, my lord, notwithstanding anything contained in paragraphs 22 and 23, second-hand capital equipment, sorry, my lord, volume 18. My lord, it's a thin volume. 575, my lord, was, my lord, the policy.
Yes.
It starts, my lord, from there. Then, my lord, kindly come to, my lord, page, my lord, 585, where I was. My lord, clause 24. My lord, kindly take, my lord, clause 24. Notwithstanding anything contained in paragraphs 22 and 23, second-hand capital equipment and any other second-hand goods shall not be imported unless permitted by this policy or in accordance with a license issued in this behalf. All right, I pause here. I had, my lord, placed the policy which is at, my lord, page 575, and yes, 575, my lord, your lordship will find that, my lord, under 39B, lord, 39B3, my lord, your lordship will find, my lord, note 4, foreign investment must cover the cost of imported capital goods, which must be new and not second hand. So, my lord, and my lord, 580, your lordship will also find the right hand column, the clause 3, my lord, investments in priority industries under 100% scheme. Now, my lord, kindly come to, my lord, just above subclause A, Reserve Bank will grant approval for such proposal, provided contributions received from NRIs towards equity shares, convertible debentures covers the foreign exchange requirement for import of capital goods, if any. The plant and machinery proposed to be imported must be new and not second hand. Page 580, my lord. My lord, I showed 2 pages here. Page 575. My lord, which
Yes, 580 you had read on the last date.
yes, and
Yes.
my lord, 580.
Yes.
Policy says, my lord, that it's has to be new.
Yes.
My lord, for, my lord, any, my lord, kind of issue of shares. And my lord, 24 says, clause 24 at page 585.
Yes.
Notwithstanding anything contained in paragraphs 22 and 23, second-hand capital equipment and any other second-hand goods shall not be imported unless permitted by this policy or in accordance with a license issued in this behalf. So, my lord, there is to be no import of second-hand capital goods. My lord, if the policy does not provide for it, or, my lord, there has to be a license. Now, my lord, kindly read, my lord, 25 also, clause 25.
Yes.
This is also, my lord, important. All second-hand capital goods having a minimum residual life of 5 years may be imported by the actual users without a license, subject to actual user condition. The actual user shall furnish to the customs at the time of clearance of goods a self-declaration to the effect that the second-hand capital goods being imported have a minimum residual life of 5 years in the prescribed form as given in Appendix 11 of the Handbook of Procedures. If the CIF value of second-hand capital goods being imported is rupees 1 crore and above, the importer shall also furnish to the customs at the time of clearance of goods a certificate from an international reputed inspection and certification agency to the effect that the purchase price is reasonable. So, my lord, first, my lord, there's no question of, my lord, any, my lord, import of second-hand capital goods unless the policy permits it or there is a license to such effect. That's, my lord, the first. Here, my lord, policy, my lord, does not permit, my lord, second-hand capital goods. In any event, policy does not permit import of second-hand capital goods against issuance of shares, whether, my lord, repatriable or non-repatriable basis. It's, my lord, blanket. Third thing, my lord, is it can be imported without a license, provided, my lord, the other restrictions don't apply. my lord, only if, my lord, there is a declaration to the effect, my lord, that it has, my lord, a minimum residual life of 5 years. And if it is 1 crore and above, then, my lord, that, my lord, the purchase price is reasonable. Now, my lord, keeping this in mind, your lordship seen all the orders which I placed, etc. Now, my lord, come straight away. Yes. And, my lord, the declaration form, my lord, which has to be filed, my lord, is at page 588. Kindly have a look at this, my lord, before I just go straight away, my lord, to the order which was impugned in the writ petition, and then the order passed in, my lord, the writ proceedings. My lord, page 588 to 589, my lord, is, my lord, the form of the declaration. My lord, there's a typed copy also at 590. My lord, at the top, your lordship will find
88.
588, my lord. Appendix 11 and 11A, declaration for import of second-hand capital goods and inspection and certifying agencies. Appendix 11, form for furnishing declaration, and, my lord, the list of inspection on certification agencies are also given. So, my lord, they have to have a certificate by these agencies that, my lord, the purchase price is reasonable, and the declaration, my lord, has to, my lord, say, my lord, what the residual life is. It has to be minimum of 5 years. And, my lord, just on a factual, my lord, aspect, admitted position, there was no such declaration regarding the import of, my lord, these goods, against which, my lord, shares were, my lord, issued. And secondly, my lord, there was no certification by, my lord, any of these agencies.
Yes.
Now, my lord, this is, my lord, the position. Now, kindly come to, my lord, the order, my lord, of the Reserve Bank of India, my lord, which is, I believe, in the convenience compilation filed by my learned friends. My lord, it's at page 258 of volume 2, my lord, of that compilation.
Speaking order.
Speaking order, my lord. Lordship recalls, my lord, this is the present one is the third writ petition. First writ petition order, my lord, required, my lord, the Reserve Bank of India recognize the dispute as a dispute between two brothers relating to shareholding in the company, and required the Reserve Bank of India, my lord, to address, my lord, 3 issues when, my lord, granting, my lord, considering grant of approval. Now, kindly come to, my lord, page 272.
Yes.
My lord, if I may just, my lord, place this. This is the first issue. I am of the opinion that the Reserve Bank has a rather a limited role under the provisions of FERA 1973 in the dispute between the parties. And there are 3 issues to be addressed. I will address them serially as follows. First issue, whether approval shall at all be granted or not. My lord, this was the order of the learned single judge also. Now, my lord, kindly just make a note, pages 272 to page 275.
Yes.
My lord, is, my lord, the adjudication, my lord, of, my lord, the first issue. Now, my lord, here, if I may just, my lord, place page 273. My lord, third line. Admittedly, in this case, the equipment supplied by Dr. K.K. Dotto was second hand, and there is no dispute on this point. Now, my lord, I pause here. So, my lord, there is a finding that, my lord, the equipments, my lord, were, my lord, second hand. Then,
Yes.
my lord, kindly come to, my lord, 3 lines thereafter. The import of the equipment, the lordship has that, my lord, was governed by the then exempt policy, in terms of which there was no restriction on import of second-hand capital goods. I pause here. This is completely contrary to
There
the
was a
policy.
bar in the policy of SIA.
Complete bar. And here, my lord, they say admitted possession second-hand capital goods. And, my lord, they hold, my lord, that there is no bar, which, my lord, in my respectful submission, my lord, is, my lord, completely, my lord, contrary, my lord, to the policy. Then, my lord, kindly come to, my lord, the facts, my lord, which led to, my lord, this writ, my lord. Yes, kindly come to page 275. In view of the above, my lord, third line. I am of the opinion that the Reserve Bank of India's permission for issue of shares shall be granted in terms of section 19(1)(d) of FERA. Permission granted to, my lord, RGHL is the company, my lord, to issue shares to the person resident outside India shall also be treated as permission to such person resident outside India to acquire or hold such shares under 29(1)(b). Now, my lord, on the face of it, my lord, I have, my lord, 4 grounds, my lord, to challenge, my lord, this finding. First is, my lord, it is based on, my lord, a conclusion arrived at that, my lord, the policy did not bar import of second-hand capital goods against issue of shares. My lord, this is completely contrary to the policy. That's number 1. Number 2, my lord, is, my lord, Reserve Bank of India, when it is considering grant of approval under section 19(1)(d), as also, my lord, section 29(1)(b), is required to follow the policy. My lord, it cannot grant approval if it is contrary to the policy. And third, my lord, there was no declaration or certification as required, my lord, under clause 25.
Yes.
Which could have, my lord, permitted, my lord, import of second-hand capital goods. Even that factor has not been considered, my lord, by the Reserve Bank. Now, my lord, here, my lord, I, my lord, rely on 2 cases, my lord, for the proposition that when an authority, a statutory authority, is discharging a statutory function, it has to act in aid of, my lord, the government policy. And second, this is more particularly so here because the Reserve Bank of India also, my lord, in its in-principle approval, had said that, my lord, the policy has to be followed. I placed that document earlier already, my lord, which is, my lord, in which is at page 181, my lord, of their compilation. My lord, I'm not troubling your lordship with it again, my lord. The in principle approval, my lord, it specifically says that it has to be as per exim policy. And my lord, the SIA approval, my lord, which my lord was granted under para 39B, my lord, specifically mentions that it is binding on the Reserve Bank of India. And my lord, which says, my lord, it has to be as per exim policy. These have all I've placed, my lord. Now, my lord, in aid of this, my lord, the two cases, my lord, which I wish to rely on are 2008, 15 Supreme Court cases. My lord, paragraph 19.
2008 15 SCC.
SCC 166 at para 19. My lord, we've handed up a compilation of cases. Helpful finding. My lord, it's page 38, my lord, of the compilation. My lord, kindly come to para 19, which is page 46 of the compilation. My lord. My lord, this is 2018, 15 Supreme Court cases, 166. 2008? 2008, 15 SCC. My lord, 388. 38. My lord, para 19. My lord, 38 is the compilation page. The report page is 166. My lord, kindly take para 19, which is compilation page 46.
Yes, we have it.
My lord, may I read it, my lord? This case demonstrates, though in a very limited manner, the lack of cooperation and coordination between government departments. All departments should function in the interest of the public and for public good. Merely because a particular department or an authority functions under a particular statute, it does not follow that they should or could ignore the provisions of other statutes. Interdepartmental cooperation and coordination is vital for the smooth and successful functioning of the government. But unfortunately, there is thriving interdepartmental rivalries and a mutual non-caring attitude towards the functioning of other departments and enforcement of other statutes. Non-cooperation between revenue and forest department, revenue, mines, forest and so are too well known, unless immediate, etc. Violators will walk away, national resources and public interest, be that as it. This is, my lord, they have to act, my lord, in aid of each other. And more particularly so, my lord, because, my lord, in this case, it has been specifically, my lord, the documents are, my lord, on record. My lord, in, my lord, page 561 of volume 18, which I had handed up. My lord, kindly have a 559, my lord, is the SIA approval. 559. My lord, my lord, kindly come to page 561, subclause 7. Lordship will find, my lord, this approval letter is made a part of the foreign collaboration agreement to be executed between you and the foreign collaborator, and only those provisions of the agreement which are covered by the said letter or which are not in variance with the provisions of the letter shall be binding on the government of India or Reserve Bank of India. So, my lord, this is, my lord, absolutely, my lord. And, my lord, next, my lord.
4 at page 563.
And, my lord, the in principle approval also, my lord, is in the same volume.
Yes.
At page 569. Lord, sorry, my lord, 569. My lord, this is the Reserve Bank of India's letter, my lord, which also says,
Abide by the terms and conditions.
I'm grateful. And this has been, my lord, completely, my lord, ignored. Now kindly take the second case, which is page 1, my lord, of the compilation. 2013-16 SCC 490.
Yes.
My lord, kindly have a look now, my lord, at para. My lord, I'll just indicate the para numbers I'm going to rely on. And, my lord, paras 2, 3, 24 to 26, and 32 to 34. Now, my lord, kindly have a look at para 2. My lord, because FERA is involved, my lord, in this case. Paragraph 2, my lord, which is compilation page 9. Lordships have that, my lord?
Yes, we have it.
The Special Director of Enforcement Directorate, Government of India, New Delhi, exercising powers under Section 51 of FERA, later repealed, initiated proceedings with a order dated against Maple for violation of provisions of so-and-so, read with Section 68 of FERA. The proceedings were also initiated against other respondents, including the first respondent, so-and-so, so-and-so. The respondents, aggrieved by the aforementioned order, preferred 4 appeals before so-and-so and the tribe. Union of India, aggrieved by the said order, preferred criminal appeal number so-and-so before Delhi High Court under 54, read with 35, which was, however, dismissed, stating that neither any question of law nor any legal infirmity had been found in the impugned order passed by the tribunal. Aggrieved by the same, criminal appeal has been filed by Union of India, which is treated as the main appeal, etc. Now, my lord, kindly come to para 24. At, my lord, page 510 of the report, page 21 of the compilation. Paragraph 24, my lord. Government of India had decided to take up series of initiatives in respect of, your lordship has that, my lord?
Yes, we have.
In respect of policies relating to the area of industrial licensing, foreign investment, foreign technology agreements, public sector policy, MRTP in industrial policy, for achieving social and economic justice to end poverty and unemployment, and to build a modern, democratic, socialist, etc. It was felt necessary that India should also grow as part of the world economy and not in isolation. Para 24 of that policy stated that the government would welcome foreign investment in high priority industries requiring large investments in advance, for which approval for direct investment up to 51% was permitted. Para 26 noted the promotion of exports of Indian products, called for a systematic exploration of world markets through intensive and highly, etc. Para 39B of that policy dealt with foreign investment, portions of which are relevant for the purpose are given below. My lord, we are under 3. Lordship has, my lord, next page, 39B3. Other foreign equity proposals, including proposals which do not meet the, will continue to need prior clearance. Foreign need not necessarily be accompanied, so and so. Then, my lord, kindly come to 26. The policy referred to above would show that it was focusing on foreign equity on high priority industries as per 39B1, and for other foreign equity proposals involving 51% foreign equity as per prior clearance was required to be obtained in the past. In other words, there was no change in industrial policy except for items covered under so and so. Then, my lord, kindly come to para 32. The press note mentioned above has therefore dealt with 39B4 and stated that majority of foreign equity holding up to would be allowed for trading companies primarily engaged in export with thrust would be so and so. Press note also indicated that no general permission for investment under automatic route be given and an application will have to be filed before RBI as per para 6, which takes in both new and existing companies. Para 6 therefore clearly indicates that the application for approval by RBI is mandatory for the new as well as exist. Therefore, if a new trading company indulging in export primarily also will have to make an application to RBI for automatic approval for foreign investment, etc., etc. Then, my lord, we may now refer para 33 to the scope of notification so and so as amended and notification. The notifications referred to above have laid down certain conditions and parameters to be complied with by companies registered in India for automatic approval. And those notifications, kindly note this, have to be read along with sections 19(1)(a) and D, section 29(1)(b) of FERA, industrial policy and press notes. Before examining the scope of so and so, let us examine the arguments advanced by as to whether so and so Maple was in there. So, my lord, they all have to be read, my lord, together. So, my lord, when, my lord, a 19(1)(d) approval or a 29(b) approval, my lord, is 29(1)(b) approval, my lord, is being accorded, my lord, the policy, my lord, has to be taken into consideration. And approval cannot be granted, which is contrary, my lord, to the policy.
Yes.
Then, my lord, now kindly come to the second issue, my lord, in, my lord, the RBI, my lord, order. Page 275 of, my lord, convenience compilation 2 of, my lord, filed by my learned friend.
Yes. Second issue.
Yes. Whether the approval, my lord, I'll just show whether the approval shall be on non-repatriation basis alone. As discussed above, the equipment supplied by Dr. K.K. Dotto was second-hand. The company had received and utilized the same, for which Dr. Dotto had made payment abroad. Since, as per the then existing policy of RBI, capitalization of second-hand equipment could be permitted on non-repatriation basis only, I am of the view that permission shall be granted for issue of shares on non-repatriation, though there was conflicting claims and counterclaims regarding functionality or dysfunctionality of the medical or its valuation by both parties, producing various documents and papers in support of their stand. I am of the view that it is beyond the scope and purview of my investigation to delve into each and every claim. Now, my lord, my lord, have, my lord, three things to say here. My lord, apropos, my lord, the finding of, my lord, finding on the second issue.
Yes.
My lord, there is a reliance on, my lord, a Reserve Bank of India policy. It says this is justified under Reserve Bank of India policy. Now, my lord, we do not know what this policy is. No such policy, my lord, was disclosed, my lord, to us. And even, my lord, in, my lord, the affidavits which have been filed, there is no policy, my lord, of the Reserve Bank of India permitting this. Second, my lord, in any event, the policy which was governing, my lord, allotment of shares here and import of capital equipment was the policy under 39(b)(3), which prohibited, my lord, second-hand capital equipment. Third, my lord, it does not go into the functionality of the equipment at all. Though, my lord, the order of the learned single judge in the writ petition, my lord, dated 22nd March 1999, which is in the convenience compilation, page 225. Millard specifically provides, Millard, that Millard, whether Millard there would be monetary limit to the number of shares which shall be the subject matter of such approval. They say it's beyond their scope. Now, Millard, it cannot be beyond their scope. First, because the order, Millard, does not, Millard says, Millard, it is within their scope. Order required this to be decided. And why so? Because, Millard, what is important is, even if second-hand capital equipment, Millard, is permitted under actual user, Millard, there has to be a certification by an authorized agency with a declaration. Declaration that residual life is more than 5 years, and certification that purchase price is, Millard, reasonable, which were totally absent. And, Millard, it abdicates, Millard, its duty. In fact, Millard, kindly make a note, Millard, of, Millard, page numbers, Millard, which I want to give your lordships. Millard, volume 6 of the appeal paper book.
Yes.
Millard, pages 847, 849, 850, 852, 854, 867, 869 at 870, 872, 874, and 878. Well, these are letters issued by the manufacturers of equipments showing, Millard, that the concerned equipments on the date of import could not have had a residual life of 5 years, that they were obsolete.
These letters was placed before
Yes, and not considered. They say, we don't need to go into it. Because, Millard, the claims, counterclaims with regard to functionality, dysfunctionality, they said we don't need to go into it because RBI policy is there on non-repatriation basis against second-hand capital. That's issue 2, Millard, how they've decided it. Then, Millard, doctor's letters, Millard, the next set of, Millard, documents. Millard, doctor's letters, Millard, volume 7, page 893, 896, 903, and 913, which again militate against, Millard, this residual life. Now, Millard, I'll give an example. Millard, I don't want to trouble your lordship, Millard, with all, Millard, the letters. No, I'm showing from these letters. So first come to these letters, okay? Millard, kindly come to, Millard, 847 once.
Give volume 6.
Volume 6, Millard. This is the best letter they want. I am showing these documents, please. My lord, kindly come straight away to page 849, my lord. The typed copy is at page 850. I'm giving, my lord, one letter. My lord, 92 to 95, my lord, was the period of importation.
You're
My lord,
referring to 849.
yes, my lord, 849. Kindly come to 850. Typed copy, my lord. It might be more legible.
Yes.
My lord, 92 to 95 is the period of importation. I've given the bills of entry. This is a letter of January 1996. Well within the period of 5 years. Further to our letter dated so-and-so, on the above subject, we wish to clarify that we are willing to undertake the maintenance of the Sen ventilators without compressors or all humidified airs. As per our engineer's inspection report of ventilators at our hospital, we wish to inform you that the compressors and humidifiers used with the have become obsolete, and as such, no spares for these are available. There are total of so-and-so. Clarify this, we defer. Contract service will cost you so-and-so. Now, my lord, kindly have a look at 878. Just, my lord, one example, my lord. 878.
And when is this letter being written? In 96?
96, my lord. Within the, my lord, 5-year period.
Which page there are?
My lord, 8. Kindly have a look at 878. My lord, this is also 12th March 1996. Please refer to your query regarding so-and-so and so-and-so of your hospital which were inspected. All the models of the 7000 series are more than 10 years old. So-and-so we have been seen as even older than the above, whose production was stopped in 1981. Hence, we are unable to extend any service. Now, my lord, just one, my lord, doctor's letter 913.
Volume 7.
My lord, this is of 1995, 1st August 1995. Cardiac surgery held up due to heart-lung machine malfunctioning constraints. Completely, my lord, dysfunctional. These are all on, my lord, record. Now show their letter. Now, my lord, yes. Now, my lord, kindly
Who is
take,
this gentleman writing this letter?
my lord, this is, my lord, the vice president, my lord, of, my lord, Ruby General Hospital, Brigadier R.K. Rakshit. My lord, he's the, my lord, person at site writing to Kamal Datta.
On for what? Why? What?
My lord, Kamal Datta was the director. My lord, he
What
is,
prompted him to issue this letter?
because
It is
hospitals
written in
held
what
up.
context? Just
lord,
as a routine communication?
my lord,
Or
reporting to the director, my lord. He's reporting to the director.
IDBI letter gone.
913, my lord.
Yes, we have it.
My lord, this is a reporting, my lord, to, my lord, the managing director. 9.
So this is dealing with many issues which are arising.
Correct.
And in the course of that, he has also
It's
touched
also there,
upon
my
one of
lord,
the
it's there.
machines
Correct.
which has been imported.
And my lord, kindly have a look at and my lord, on 6th of April 1999, there was also a survey conducted, my lord, of these equipments because a dispute had arisen there.
So heart-lung machine was one of the machines.
Yes. My lord, this is, my lord, one of the certification agencies.
You are referring to another document.
Yes, 924, my lord.
That document you did not ask us to take note of. 924.
No, this is, my lord, your lordship's right. Those were doctors' letters and, my lord, manufacturer agents' letters. This is, my lord, a third category, my lord, of, my lord, a certification agency. Who is, my lord, one of those listed, my lord, in, my lord, the import policy. Your lordship remembers, my lord, Appendix 11, Appendix 11A, my lord, the list of certification is SGS.
Yes, this is about 4 years after import.
Correct. And my lord, kindly see item 3, Dr. Nirmal Maji, Assistant Secretary, Indian Medical Association, Subhash Chakraborty, Joint Secretary, Indian Medical Association, A.K. Chakraborty, ex-surgeon superintendent, 3 independent, my lord, persons were present. And my lord, the report is to, my lord, relating to condition of equipments at present stage, reasonability of pricing at which they were acquired. Now, my lord, kindly have a look at the next page. On going through the documents, it was observed or supplied by so-and-so. We have carried out survey of condition and as is, where is condition, and we report as annexure. Condition of equipments in general on as is, where is basis are as per following. In some equipments, manufacturer's name, model, serial are illegible, could not. Equipments appear to have been used for a long time and not been used for a long time and discarded. At the time of survey, same equipments observed is allotted down condition, wires removed apparently, non-functional, redundant. And then, my lord, the annexures, my lord, are there, my lord, supporting this. These were all there, my lord, before, my lord, the Reserve Bank of India. But they say we don't need to go into it because RBI policy permits this. And my lord, I want to show your lordship, my lord, one other aspect of the matter. My lord, the respondents, my lord, before your lordship, also did not want, my lord, the Reserve Bank to go into it. Now, my lord, kindly see their submissions before the Reserve Bank of India. Page, my lord.
Whether they wanted or they didn't, it's your case that the RBI didn't go into.
And my lord, all that I'm showing, my lord, is, my lord, even their case, my lord, was you don't go into this. Why? Because this writ petition is pending. Kindly, my lord, I want to show your lordship, my lord. The first writ petition is pending, 268.
268 of the convenience paper.
Yes, my lord, volume 2. 260 is the RBI, my lord, order, which I was placing.
268.
Yes. Roman 5.
To the issues.
Yes, raised by the petitioner regarding second-hand equipment, whether machines were functional or not. He submitted that respondent had filed a number of documents which was subject matter of writ jurisdiction before Honorable Calcutta High Court in writ petition, and as such the matter was sub judice and was beyond the scope of hearing. And that is the order which directs Reserve Bank of India to go into all this. Now, my lord, kindly come to the third issue. My lord, convenience compilation, page 275, volume 2.
Page?
My lord, 275.
Yes.
My lord, kindly see third issue. A permission shall be granted for issue of whether there shall be any monetary limit or limit to the number of shares. Now, my lord, kindly see. Permission shall be granted for issue of so-and-so shares against import of second-hand medical equipments on non-repatriation basis for which he has made payments abroad and in support of which he had submitted documentary evidence at the time of making application, which was scrutinized and found to be in order. I hereby direct. Now, my lord, again, my lord, the same points, my lord, with regard to policy, etc., second hand prohibited, all that, my lord. And my lord, there is no proof of payment. He's given an invoice, he says payment has been made. No bank accounts disclosed, no receipts, my lord. And the other issues not examined at all. Now, my lord, this being the position, my lord, we filed, my lord, the present writ petition saying the order, my lord, of this court in exercise of its jurisdiction under Article 226 had not been complied with, and the order of the Reserve Bank was incurably bad, being contrary to the policy which was binding on the Reserve Bank of India. Now, my lord, kindly see what the learned single judge, my lord, has, my lord, held. It's, my lord, the order of 16th of March 2016. And, my lord, it's in their compilation, volume, my lord, 2, page 344. My lord, kindly take, my lord, internal page 12 of the order, my lord, which is, my lord, at page 359. My lord, because, my lord, this is the portion, my lord, which deal with merits.
Yes.
Now, kindly see, my lord, now I come to the last point, but the most vital and decisive. The Foreign Exchange Management Act came into force on 1st June 2000. The repeal and savings clause of this act is very important. It is section 49. Now, my lord, section 49 is set out. Subsection 1. My lord, 2 is not set out. 3, 4 and 5. Now, my lord, kindly see. The Foreign Exchange Regulation Act 73 is hereby repealed and the appellate board constituted under subsection 1 of section 52 of the Act shall stand dissolved. Then, my lord, notwithstanding anything contained in any other law for the time being in force, no court shall take cognizance of an offense. Kindly mark, my lord, this word. An offense under the repealed Act, and no adjudicating officer shall take notice of any contravention under section 51 of the repealed Act after the expiry of a period of 2 years from the date of commencement of this Act. Then, subject to the provisions of subsection 3, all offences committed under the repealed Act shall continue to be governed by the provisions of the repealed Act as if this Act had not been repealed. Then, my lord, 5 is very important. Notwithstanding such repeal, anything done or any action taken or purported to have been done or taken, including any rule, notification, inspection, order or notice made or issued, or any appointment, confirmation, declaration made, or any license, permission, authorization, exemption granted, or any document or instrument executed, or any direction given under the Act hereby repealed shall, in so far as it is not inconsistent, be deemed to have been done or taken under the corresponding provision. Now, my lord, the argument was Mr. Kapoor submitted that after the sunset period of 2 years, which is long over, no irregularity or illegality in the purchase of second-hand medical equipments by the company could be alleged or proved. Moreover, after repeal of FERA, no permission was required to import medical equipments. Therefore, assuming that any equipment was illegally imported before that period, in the absence of any action, it became legally imported after the sunset period. So this was the argument advanced, that more than 2 years have passed since the date of importation, from the date of enactment of FEMA. Therefore, you cannot look into any illegality of this importation. And in any event, under the new act, there is no bar to importation of second-hand equipment. Therefore, it is a valid, today it stands as a valid import. Mr. So-and-so appearing for the writ petitioner submitted that the rights of his client under Section 6 of General Clauses Act were preserved despite the sunset provision. There is no dispute that no permission is required from Reserve Bank of India to allot shares on importation of capital goods to non-resident Indians under the Foreign Exchange Management Act 1999. Now, even if we assume that the decision dated 7th May 2004 was wrongly made by the Reserve Bank of India, and also assume that Foreign Exchange Regulation Act 1973 is still in force, the following courses of action are open to the court. Dismiss the writ application on the ground that no case has been made out by the writ petitioner regarding violation of principles of natural justice by RBI, or that its order is otherwise erroneous. Then B, holding there was violation of principles of natural justice by Reserve Bank of India, an impugned order was erroneous, and remit the matter back to Reserve Bank of India to consider afresh. Under this subsection, only this course of action is open to me in view of the dictum of the Supreme Court in LIC that the power vested in the Reserve Bank of India can only be exercised by it and nobody else. So, my lord, there are only two, my lord, possibilities which are being examined, my lord, by my lord, the learned single judge. Let us also assume that the decision of this court is B. In that event, the Reserve Bank of India, assuming that it rules in favor of writ petitioner, will have to rule that permission to import medical equipment was wrongly obtained from it by the company represented by Kamal. The Reserve Bank will have to refer the matter to the authorities under Foreign Exchange Regulation Act 1973 to deal with the company and Kamal. In addition to imprisonment, Kamal will have to pay penalty, etc. No greater punishment is contemplated. Now the General Clauses Act comes into play. I quote Section 6 A, C and D. A, C, D and E. Well, revive anything not in force or existing at the time at which the repeal takes effect, or affect any right, privilege, obligation or affect any liability, etc. What rights and obligations under FERA were preserved and for how long need to be investigated. Neither adjudication of penalty nor criminal prosecution can be undertaken as the period of 2 years from the date of commencement. Either a civil proceeding for penalty had to be started by issuance of show cause notice, or cognizance of offence should have been taken by a criminal court within 2 years and so. Since it came into effect on 1st June, any action should have been taken by 31st May. The preservation of all rights and liabilities under FERA were restricted for this period and to this extent only. I join issue here. Whether there could be no criminal proceedings, civil consequences, my lord, remain. Then, my lord, at this point of time, even if it is assumed that importation was wrongful, no action can be taken by operation of law. If a new statute after repeal of an act does not contemplate any action in relation to a past illegal act under the repeal statute, then the new statute has the effect of legitimizing that illegality. Mr. Justice Krishna Iyer said in Rameshwar and others, reported in so-and-so, that court had to take note of change in law. Furthermore, the Reserve Bank of India in its written submission, as well as through oral argument made by counsel in court, has categorically stated that second-hand medical equipments of rupees so-and-so were accompanied by proper documents and cleared by custom. Therefore, approval was rightly given by Reserve Bank to issue so-and-so each to Kamal. As the Supreme Court has said in Escort's case, only the Reserve Bank of India can exercise the power vested in it, and no authority has got any right to interfere with the exercise of the power. It is very plain from the stand taken by Reserve Bank that importation was perfectly lawful. And my lord, I am showing, my lord, on the face of it, it's contrary to the policy. Then, my lord, lastly, the importation was made more than 20 years ago. These capital goods have spent their life. Their value now after depreciation is nil. At the time of their importation, declared value was so and so. Against this value, shares were allotted. Even if Sojol now succeeds, equipments cannot be returned. Monetary value has to be refunded with interest from other assets. That is plainly not permissible or feasible. In all those circumstances, writ application fails, is dismissed, no order, etc. Now, my lord, I have, my lord, few points, my lord, here to make. My lord, first is, my lord, the order, my lord, passed by the learned single judge completely ignores, my lord, the exempt policy under which, my lord, the importation was made. Paragraph 39B3 of, my lord, the import policy, my lord, is completely ignored. Because, my lord, the learned judge ignores, my lord, the exempt policy of 39B3, the learned judge, my lord, also ignores the position in law that this policy was binding on the Reserve Bank of India. When exercising jurisdiction under section 19(1)D and section 29(1)B. And third, my lord, the learned single judge, with the greatest of respect, has, my lord, misinterpreted section 6 of the General Clauses Act. Now, my lord, kindly have a look at, my lord, section 6, my lord, of, my lord, the General Clauses Act. Copy, Lord, I have copies. Kindly see, my lord, effect of repeal. FEMA. Copies को FEMA. My lord, I just want to, my lord, before that, my lord, just place, my lord, section 49, my lord, of FEMA. What is this? My lord, it's there in the compilation.
Yes.
Lord, section 49. Page 6, my lord, kindly take. My lord, 1st June 2000, my lord, this came into force.
Page 6 of?
My lord, this is the compilation. First compilation, my lord, of lord, statutes, etc., my lord, relevant provisions, they've given section 40.
Yes.
Lord, may I just place that? The Foreign Exchange Regulation Act 1973 is hereby repealed, and the appellate board constituted under subsection 1 of section 52 of the said act shall stand dissolved. Then, my lord, subsection 2. On the dissolution of the appellate board, the person appointed as chairman of the board and every other person appointed as member and holding office as such shall vacate, and no such chairman shall, for premature termination. And then, my lord, 3, 4, and 5, my lord, which are referred to in the order, my lord. But most important is, my lord, subsection 6. My lord, the impugned order has set out, my lord, 3, 4, and 5, subsections 3, 4, and 5. Kindly have a look at subsection 6. Save as otherwise provided in subsection 3, the mention of particular matters in subsections 2, 4, and 5 shall not be held to prejudice or affect the general application of section 6 of the General Clauses Act with regard to the effect of repeal. So, my lord, to the extent that, my lord, the provisions of FEMA, my lord, section 49 curtails section 6, section 6, my lord, has application in full force, my lord, to the repeal. Now, kindly take, my lord, the General Clauses Act. My lord, that's in page 10 of the compilation. It's also there separately. I've handed up.
Just give us a
Yes.
6. Yes.
Now, my lord, kindly have a look at section 6. Where this act or any central act or regulation made after the commencement of this act repeals any enactment hitherto made or hereafter to be made, then unless a different intention appears, the repeal shall not, my lord, kindly take B, affect the previous operation of any enactment so repealed or anything duly done or suffered thereunder. Then C, affect any privilege, any right, privilege, obligation, or liability acquired, accrued, or incurred under any enactment so repealed. Then E, affect any investigation, legal proceeding, or remedy in respect of any such right, privilege, obligation, liability, penalty, forfeiture, or punishment as aforesaid. And any such investigation, legal proceeding, or remedy may be instituted, continued, imposed, and any such penalty so and so may be imposed but not be imposed. Now, my lord, all that the sunset clause does, my lord, is take out criminal liability because it's an offense. Civil consequences are not affected at all. So, my lord, after 2 years after, my lord, enactment of FEMA, that's June 2002.
Subsection 3 and 4 have to be read together.
Correct. Absolutely. Absolutely. Because 3 says, notwithstanding anything contained in any other law for the time being in force, no court shall take cognizance of an offence
Offences.
under the repealed act.
Yes.
And no adjudicating officer shall not take notice of any contravention under 51 after expiry of period of 2 years. Subject to the provisions of subsection 3, all offences committed under so and so shall continue to be governed by the provisions of the repealed act as if the act had not.
Yes.
Now, my lord, if civil rights obligations and liabilities are not affected, and that's my respectful submission before your lordship, my lord, then, my lord, no shares could have been directed to be allotted in, my lord, of approval granted for allotment, my lord, against import of second-hand capital equipment. None. And, my lord, one decision I wish to cite, my lord, this is, my lord, in our compilation which we have handed up, page 422. My lord, this is, my lord, reported in All India Reporter, 1969 Supreme Court, 204. My lord, kindly take, my lord, paragraph 12. My lord, at page, my lord, report page 208, page 426 of the compilation. Yeah. Hello, AIR 69 Supreme Court 204, para 12.
Paragraph 13.
12, my lord, 12. My lord, this, my lord, matter came, my lord, from the Patna High Court. My lord, it had to do, my lord, with regard to settlement of Santhal land, my lord. My lord, whether a transaction was valid or invalid was, my lord, the question. Now, my lord, kindly look at para 12. My lord, at page 208.
Under the SPT Act.
Correct. Counsel for the respondent, however, contended that section 27 does not in express terms mention an exchange, and therefore a transaction of exchange was beyond the scope of that section. Under section 118 of the Transfer of Property Act, a transaction is exchanged when two persons mutually transfer the ownership of one thing for the ownership of another, provided it is not an exchange of money only. A transfer of property in completion of an exchange can be made only in the manner provided for the transfer of such property by sale. It is not therefore right to say that an exchange does not involve transfer of property and therefore does not fall within the scope of section 27. As aforesaid, the language of section 27(1) is comprehensive enough to include any agreement or contract of exchange, and consequently it must be held, given the other conditions of that section, that that section would apply to a transaction of exchange. Now, my lord, it is true that section 27 and 28 of the regulation were repealed by the Santhal Tenancy Supplementary Provisions Act of 1949. But section 27 was in force when the said transaction of exchange was made, and governed the transaction made by Nilomani Dasi and Premomohi Dasi. The transaction being invalid and void, the fact that Section 27 was subsequently repealed made no difference, as the repeal could not have the effect of rendering an invalid and void transaction a valid and binding transaction. My lord, a repeal cannot ever lead to, my lord, validation, my lord, of an illegal act unless the repealing provisions or the provisions by which a repeal is effected, my lord, make, my lord, such a provision. And what, with the greatest of respect to the learned single judge, what has been done here is to convert, my lord, an ex facie illegal act into a legal act, giving, my lord, the benefit of, my lord, substantial shareholding to, my lord, the respondent. Now, my lord, the decision which, my lord, I'm sorry, the decision relied on, my lord, by the learned single judge
Yes.
my lord, your lordship will find that, my lord, at page 362 of the compilation, my lord. My lord, All India report. My lord, All India Reporter 1976 Supreme Court, page 49. My lord, All India Reporter 1976 Supreme Court 49. No. Say.
It's in this compilation.
Yes, it's there, my lord. Mother, बताओ जाना.
76 Supreme Court.
Yes, page 49. But it's at page, my lord, 137.
Yes, we have got it.
Yes. Kindly have a look at paragraph 5.
Paragraph, please.
Lord, paragraph 5 and 7, my lord, I will draw your lordship's attention to. My lord, does not say that an illegal act merely because of repeal my lord gets, my lord, validated. Kindly have a look at para 5 and then para 7.
So more or less the same. That the rights get determined on the date of the event.
I'm grateful. My lord, law might change, relief might be molded, but my lord, important thing is if an illegality is committed, my lord, unless, my lord, the repealing provision, my lord, while repealing the earlier act, validates an invalid transaction, my lord, there's no question of an invalid transaction merely by virtue of repeal, my lord, getting validated. My lord, kindly see para 5. The solitary point. Kindly take para 5.
Yes.
The solitary point which thus falls for determination is as to whether the subsequent event of the landowner's death at the appellate stage unsettles the right acquired by the tenants, or whether the tribunal must uphold rights which have crystallized as on the date the applications were made, and in any event the deposits of the first installments were made by each of the tenants. We see no difficulty in answering this question against the appellant, but in view of the persistent submission based upon a few rulings of this court, the federal court and the high courts, made by counsel for the appellant, we may as well consider the question of law, adopting an interpretive attitude which will further and not frustrate the legislative will, in case there are alternative choices for the court. Of course, a construction which will promote predictability of results, maintenance of reasonable orderliness, simplification of the judicial task, advancement by the court of the purpose of the legislation, and the judicial preference for what it regards as the sounder rule of law as between competing ones must find favor with us. A plain reading of Section 18, without reference to consideration of subsequent events at the appellate level, yields the easy and only conclusion that the rights of the parties are determined on the date they come to court, and what is an insurmountable obstacle to any other construction is that once the deposit is made, the title to the land vests in the tenant. Agrarian reform law affects a considerable number of people, and to keep rights uncertain over a long stretch of time till appeals and reviews and revisions and other processes are exhausted is to inject unpredictability of results, for it is quite on the cards that a landlord may die in the long course of litigation, or other events may happen at later stages beyond the can rights of parties fluctuate with such certain contingencies? If so, stabilization of land ownership, so vital to the new pattern of agrarian relations, will be postponed for a long time. Is not the judicial task simplified by adopting the golden rule that the rights of parties must be determined when they seek justice, and not when the last court has had its say long years after the litigation was initiated? A system of orderliness about rights and land will result from this. More than all, the sounder rule of law as between rival claims to consideration of an indifference to subsequent events is surely that which excludes the later event factually or legally. Such a reading of the statutory scheme rhymes well with rapid agrarian reform contemplated by the farmers. These were, my lord, laws relating to agrarian reform. My lord, could, my lord, subsequent, my lord, changes in law, my lord, unsettle vested rights? Now, my lord, kindly come to para 7. The realism of our processual justice bends our jurisprudence to mold, negate, or regulate reliefs in the light of exceptional developments having a material and equitable import occurring during the pendency of litigation, so that the court may not stultify itself by granting what has become meaningless, or does not by a myopic view miss decisive alterations in fact, situations, or legal positions, and drive parties to fresh litigation, whereas relief can be given right here. The broad principle so stated strikes a chord of sympathy in a court of good conscience, but a seeming virtue may prove a treacherous vice unless judicial perspicacity founded on well-grounded rules studies the plan of the statute, its provisions regarding subsequent changes, and the possible damage to the social program of the measure if later events are allowed to unsettle accomplishment of a restructuring of the land system, which is the soul of the whole enactment. No processual equity can be permitted to sabotage a cherished reform, nor individual. This wider explains the ruling cited on and the law of subsequent events. Then, my lord, kindly take, my lord, paragraph you kindly take paragraph 9, my lord.
So this is more in the context of later and subsequent events.
Yes, para 9, my lord.
Yes.
So, my lord, here the subsequent event is repeal of, my lord, FERA. Now, my lord, kindly take, my lord, page 53, left-hand column. Subsequent events in the course of the case cannot be constitutive of substantive rights enforceable in that very litigation, except in a narrow category, but may influence the equitable jurisdiction to mold reliefs. Conversely, where the rights have already vested in a party, this is very important, they cannot be nullified or negated by subsequent events, save where there is a change in the law and it is made applicable at any stage. Now, my lord, this test, my lord, has also not been, my lord, followed by the learned single judge. This judgment has been relied upon, but completely, my lord, misconstrues, my lord, the position in law. Now, my lord, LIC and escorts, which was relied on by the learned judge, my lord, relied on it, my lord, which is at page 143 of the compilation. My lord, kindly come to, my lord, page 185, para 84. Kindly take, my lord, compilation page 186. Kindly now, my lord, the learned single judge, my lord, relied on the first part, my lord, of, my lord, compilation page 186, left-hand column. Fourth line onwards. As we said earlier, under the scheme of the Act, it is the Reserve Bank of India that is constituted and entrusted with the task of regulating and conserving foreign exchange. If one may use such an expression, it is the custodian general of foreign exchange. The task of enforcement is left to the Directorate of Enforcement, but it is Reserve Bank of India and Reserve Bank of India alone that has to decide whether permission may or may not be granted under so and so. The Act makes it its exclusive privilege and function. No other authority is vested with any power, nor may it assume to itself the power to decide the question. Then, my lord, the question may not be permitted to be raised either directly. Now, we rely on this. We do not, however, rule out the limited class of cases where the grant of permission by Reserve Bank of India may be questioned by an interested party in a proceeding under Article 226 on the ground that it was mala fide, or that there was no application of mine, or that it was opposed to national interest as contemplated by the Act, being in contravention of the provisions of the Act, rules, orders, directions issued under the Act. It ignores the second part. Now, my lord, it is true. My lord, it's the Reserve Bank which is to decide, is a statutory authority for deciding this. But, my lord, where the statutory authority repeatedly, my lord, fails to address the issues directed to be considered, and which it is required to be considered, then, my lord, in my respectful submission, my lord, the court itself, on the basis of the admitted fact, my lord, grant the relief. My lord, I am relying on. Okay. My lord, kindly take 1986 two Supreme Court cases, 679. My lord, kindly come to, my lord, paragraph, my lord, 20. My lord, at page 692 of the report. Para 20, my lord, at the bottom of 692. There is thus no doubt that the high courts in India, exercising their jurisdiction under Article 226, have the power to issue a writ of mandamus or a writ in the nature of mandamus, or to pass orders and give necessary directions where the government or a public authority has failed to exercise or has wrongly exercised the discretion conferred upon it by a statute or a rule or a policy decision of the government, or has exercised its discretion malafide or on irrelevant considerations, or by ignoring the relevant consideration and materials, or in such a manner as to frustrate the object of conferring such discretion or the policy for implementing which such discretion has been conferred. In all such cases, and in any other fit and proper case, a high court can, in the exercise of its jurisdiction under so and so, issue a writ of mandamus or in the nature of pass orders to compel the performance of, in a proper and lawful manner, of the discretion conferred upon the government or a public authority. And now, my lord, I rely on this. And in a proper case, in order to prevent injustice resulting to the concerned parties, the court may itself pass an order or give directions which the government or public authority should have passed or given had it properly and lawfully exercised its discretion. My lord, I am on the admitted facts here. My lord, finding by the Reserve Bank that this is a second-hand capital equipment. SIA approval saying it's binding on the Reserve Bank. The law that Reserve Bank has to act in terms of the policy. My lord, this permission to allot under 19(1)(d) and 29, my lord, has to go. This is, my lord, the fourth order of the Reserve Bank of India, my lord, on this issue.
Yes.
So, my lord, I am, my lord, not asking for a remand. My respectful submission before your lordship will be, my lord, that, my lord, given this admitted position, my lord, this is, my lord, what, my lord, needs to be done. My lord, the court can, my lord, itself, my lord, cancel, my lord, the approval, and which issue was not examined by the learned single judge at all. And lastly, my lord, the learned single judge says money cannot be returned. My lord, with the greatest of respect, my lord, there is, my lord, nothing, my lord, to, my lord, bar, my lord, money being returned. Nothing at all. And my lord, the important thing is the board resolution, which I pointed out to your lordships regarding the allotment, was subject to the result of this writ petition.
Yes, that you had shown us.
Yes. Now, my lord, kindly, my lord, take, my lord, the affidavit of the Reserve Bank. This is the last point, my lord, which I wish to, my lord, address your lordship on merits. My lord, it's volume 11, page 1550. My lord, my lord, this is the affidavit in opposition, my lord, filed, my lord, by the Reserve Bank of India in these writ proceedings, my lord.
Yes.
Kindly come to page 1575. My lord, the second line onwards, my lord. It may be your lordship has that, my lord. It may be pertinent to note that the government of India, Ministry of Finance, Department of Economic Affairs, by letter dated so and so, have clarified that in all such cases where the amounts are paid directly by NRI against second-hand capital goods, the investment is permissible only on non-repatriable basis. The respondent number 1 shall crave leave to refer to a copy of the letter dated. Now, my lord, kindly note, this is a letter which is being referred to for the first time in the affidavit in opposition. It's not there, my lord, either, my lord, before, my lord, the proceedings before, my lord, the Reserve Bank of India or any of the other proceedings had. Now, kindly come to 1576. My lord, last 3 lines. My lord, 1576, last 3 lines. I say that after giving ample opportunity to the petitioner number 2 and after going through the records and after second-hand machinery is based on so-and-so's Ministry of Finance decision conveying.
No, this is perhaps this page is 28, 27 is coming after 28.
Yes, my lord, I should have read, my lord, 27.
Or maybe after 28, you skip the page in between and go to 29.
Correct, my lord. Pass the order is a fit case on so-and-so. Then, my lord, is, my lord, page 1577. Kindly come to 1577.
No, if you are starting with paragraph 31, then after 1576, you go to 1578.
Correct, correct. My lord, kindly come to the bottom of 1575. Last 2 lines, my lord.
Yes.
The petitioner number 1
Yes.
was advised to issue shares on non-repatriation basis against import of, now kindly go to 1577, second-hand machinery. Machineries based on Ministry of Finance decision conveyed vide the letter where the amounts are said, where the amounts are paid directly by NRIs against import of second-hand capital goods. The investment is permissible only on non-repatriation basis. Now, my lord, kindly have a look at our affidavit in reply, page 1581, my lord, of the same volume.
Yes.
My lord, kindly take, my lord, page 1600. at page 1600. Well, 10 lines from the start, sentence starting right-hand side with regard to allegation.
Yes.
Relating to purported letter, Government of India, Ministry of Finance dated, I said that the letter was never disclosed or relied upon by the respondent authorities at the time of hearing, given by the respondent authorities to the petitioner, nor has any document been disclosed by the respondent authority to show that any letter as alleged by the respondent authorities is in existence. In such circumstances, no reliance can be placed. Now, my lord, during the hearing, now, my lord, kindly take volume 18. Lord, 595. Lord, your lordship might find, my lord, the date of handing up of the letter, my lord, also mentioned, my lord, during the course of hearing at the top. Does your lordship have that, my lord? Page 595.
Yes.
That is, my lord, the advocate's writing, my lord, kindly proceed.
This is the letter being referred to.
Correct. My lord, it was handed up. My lord, we took a point. My lord, in the affidavit, somebody has seen the light of day, my lord, of, my lord, this particular document. Then, my lord, it was handed up during the course of hearing. This is a letter, my lord, by, my lord, the government. Dear Shri Chaudhary, please refer to communications from Reserve Bank of India referring the following proposal from the companies detailed below for Government of India concurrent stroke advice. Then, my lord, the Reserve Bank letters are referred to and the proposals, my lord, have been given. Now, my lord, kindly note one thing, because this letter, my lord, seeks to justify the Reserve Bank, my lord, decision to deviate from the policy. Now, the proposals which are listed, kindly make a note. None of them pertain to paragraph 39B3 of, my lord, the EXIM policy, which specifically prohibited import of second-hand capital goods. It is in this context that, my lord, the answer is given 595, clause 2. The specific issue, kindly note this, raised in these cases are capitalization of direct payment by NRIs against import of items through issue of shares. Then, my lord, second, repatriability of such investment by NRIs in case of direct payment against imported capital goods which are new. And 3, repatriability of such investment by NRIs against direct payment of imported machinery which are second-hand equipment. Then 597, my lord. On these issues, that these 3 specific cases, RBI may take action as follows. Government of India have no objection to capitalization of payments made by NRIs directly for import of capital goods. This does not relate to second hand at all. Then in those cases where direct payment is for import of new capital, equity participation may be permitted on repatriable. In all such cases where amounts are paid directly by NRIs against import of second-hand capital goods, investment is permissible only on non-repatriable. No problem. But where, my lord, import is of second-hand is prohibited under the concerned policy, and when our SIA approval itself says that, my lord, it's binding on the Reserve Bank, my lord, this, my lord, direction for 3 of these cases cannot apply, because 4 says how Reserve Bank of India may consider these and, kindly mark the words, similar other cases on the basis of government's decision. My lord, page 597. My lord.
97.
My lord, clause
The
4.
bottom and last.
At the bottom. So, my lord, the answer for 3 cases, my lord, which were referred, of which one of them related to second-hand capital goods,
Yes.
my lord, was this answer. Then it says similar cases. But none of these pertain to 39B3, which prohibited, my lord, import of capital. And there is no such averment either. And nor does the impugned order mention this letter of the Reserve Bank of India. Fact, my lord, the stand now taken by the Reserve Bank of India, my lord, in the affidavit, my lord, clearly shows, my lord, why, my lord, a mechanical approach, my lord, had been adopted. My lord, in the impugned order. It's not even referred to, this document. Lord, those are my grateful, my lord, for
Yes. Why use? Yes. Let us proceed. We have another lot of time. You wanted half an hour, you have half an hour. Please.
Today.
Lordship now got the entire clip, but just to begin, subject matter is ordered by whereby RBI permitted
or non-repatriable goods and medical equipment for the company which has been put into by the company. Before placing the order, I would like to draw your lordship first to the first attempt or first effort made by the company. It approached the SIA for sanction of sanction to investment for an equity capital of 88%, and that scheme envisaged import of capital. Eventually, that was not followed. I'll come to that. Government of India Secretary approval, volume 18, page 559. What is that? Yes.
Yes. Yes, we just read that. Volume 18. Yes. Yes, yes, yes.
The application starts from 549 the form for foreign. The original application contemplated foreign investment of 800 lakhs, and that approval was given by SIA but was not eventually followed. Now that approval given by SIA and just basically the one-page letter, so that is very important.
Yes.
Foreign participants. Actually, 20% of on taxable basis. Taxable basis. Data capital of 900 lakhs, 900 company promoted by. So the scheme envisaged the matrix line to support it that the project is import of capital or 420 lakhs. Now, in my humble and respectful submission, this is the scheme which contemplated importation of meat, not importation. First, the scheme of it was 800 lakhs invested out of which or 20 lakhs worth of new capital equipment. Only in that case, the dividend would be repatriable basis. Dividend would be allowed to be repatriable. That was the original scheme. This envisaged that the money should come in first, 800, and out of that money, 420 lakhs would be invested. In that context, Mr. Mukherjee submitted 39B3. Envisaged this, but this was not followed. This would be evident from Justice Ajayanath Ray's order, portal, and on the basis of which the Reserve Bank passed. Now, no. Also referred to.
It says import of capital goods
Yes.
worth rupees 420 lakhs.
Yes, please.
Yes.
The contemplate entire and an application of also 800 lakhs. And that out of that 800 lakhs, 420 lakhs would be
Correct.
spent towards
Capital goods. Yes.
the
So this has not been acted upon as that is what you are saying.
what I want to say. Because this contemplated, as my learned Mr. Mukherjee said, the machinery had to be. I could also show you the patterns.
So if this was not acted upon, they have acted upon which permission?
So, not permission. I think the
Permission.
No, I'm
Yes.
this this proposal
Yes.
not acted upon by the company.
Yes.
The company lead,
Yes.
Dr. Mr. Kamal Datta, instead of investing this 800 crore and with that buying new machinery worth 420 crores, directly purchased second and imported machinery and brought it with. This entire scheme was not followed. Kindly come to Justice Ajoy Nasra's order that is recorded. That is that my compilation. I'll just play. My compilation, page 9. I have handed up.
Your compilation. Where is your compilation? Page
9. I'll place this order in detail, but for the time being, I am just saying that this was not pursued by the company, by the company in general. Recorded in paragraph 4 of this judgment. Those machines arrived in Calcutta sometime in 1994. In the beginning, the Secretary of Industrial Affairs was approved for import of new equipment. Have your lordship got that?
Yes.
But it appears that thereafter the parties presented to the authority that the equipment was demonstration not second hand. So this entire thing, that 800 crore never came and new equipment was never purchased. What instead was done was Kamal Datta purchased the second hand equipments and they transferred the bank's permission. I'll come back to the order later, my lord. May I just
This
go along?
order does nothing. It only says to comply with natural
No,
justice.
no,
That is
no,
all.
No. I'm on that. On
This does not determine any facts.
but
In
say-
fact, it says that I'm not concerned with the factual dispute and the
what I'm saying,
value usability of machine imported.
what I'm saying that I'm not the order I wanted to place only to show that 800 crore of investment initially for which SI approval was sought for was not pursued. What instead was done?
This does not establish that it was not pursued.
It was not. Because your lordship, it will see.
From where can we find in this order that it establishes this fact that proposal has been abandoned, aborted?
Paragraph 4 of that order, paragraph 4 is it not?
Yes.
Paragraph, just
Yes, yes, we have it.
This is they approached and got that order that 800 crores he would bring in, and out of which 420 crores will be invested towards new equipment. Second that. So that 800 crore capital, that scheme for which SIA approval was sought, was not acted upon. What was done? It is an undisputed case. What was done? Dr. Kamal Datto directly purchased the machinery and brought it, second-hand machinery, brought it to India and sought for Reserve Bank permission.
Yes.
Now, your lordship, I'll briefly just refer to the Reserve Bank granted formal permission on 22/3/19. That is page 126 of my compilation, but I am not referring to that. But these are not relevant anymore. I'll tell your lordship why. Reserve Bank initially granted the permission to import second-hand material on non-repatriation basis. Granted that was then at that time the Shajal had initiated some movement to issue shares and had ousted Kamal from the company, which position has been subsequently rectified by the Honorable Supreme. Now, the letter company received the letter. RBI received a letter from the company then under control of Shajal, saying that company has not applied that application, not in accordance with law. So, the RBI withdrew its permission by letter dated 2/6/1997. That is serial number 4 of my compilation. RBI withdrew. Then again, Kamal represented no, it was done properly. RBI again withdrew the withdrawal and granted the permission. That is in my serial number 6 of my compilation. All these 3 letters were challenged before Ajay Nath Rai. So these are no longer relevant. RBI gave permission, withdrew it, and re-granted permission. All these letters were challenged in writ petition, which culminated in the order of Justice Ajay Nath Rai. Now, serially, may I just place Justice Ajay Nath Rai's order for your lordship's consideration?
We have just read it.
Read it. Where it's not necessary. I'll only briefly refer to the last paragraph where Justice Ajay, just refer to the last paragraph.
Yes.
What the Justice Ajay Nath Rai asked the Reserve Bank to do.
Yes.
Because on the basis of this very order, the impugned order has been passed by RBI.
Grant a personal hearing. Thereafter, publish a reasoned order.
Section 29 of the Fair Act.
Yes.
Then particular attention. Then his lordship lays down what the Reserve Bank has to do. Particular attention to whether the approval shall be granted or not. Number one. This your lordship will find the first point in Reserve Bank's order.
Yes.
Next. On non-repatriable basis. Hello. Whether there shall be or the number of subject matter of such approval. So these are the three issues, three areas which were specified by the learned judge for the Reserve Bank to consider and pass an order. Reserve Bank was not really, in my humble and respectful submission, my lord, Reserve Bank was not really concerned about the effect of granting permission. It was only as an authority, statutory authority under the Fair Act, was to consider whether the permission should be granted from the foreign exchange angle. Reserve Bank was not considered whether the company will, how it company will give it at all will give effect to this order permission. Who will become in control? What will be the dispute? Reserve Bank was not concerned. The dispute said. It was only concerned as a regulatory authority that whether that permission should be granted under the Fair Act.
And what is this WP number?
My lord,
Page 19 of your compilation. It's not legible. You also think we were expecting you to say what it is.
Malaj, it's 525 of 1990. It's clearer at page 183 of what
525 of 2019. Yes. Yes. See, the only issue,
having said
only issue they have raised against you is that whatever permission you have given
is not accordance with the policy. Now,
let us come to that. This history,
I'm
irrelevant. Yes,
I'm exactly on that, my lord.
Yes.
My humble submission, my lord, will kindly come. I'll consider it. I'll also come back, but on the first blush, what I wanted to submit kindly, Mr. Mukherjee has referred to. I was just noting down. Para 580, volume 11. Just. Five 7. He was referring to kindly have volume 18, 575. Kindly see.
575. Yes.
He was saying that 39, the 39B, that approval for foreign investors, kindly see what the approval for. 575. Relevant features statement of industrial policy dated 24 July 1991. Kindly come to 3 industrial, etc. Then foreign investment. I'm sorry, I also referred to now. This is an approval to be given for direct foreign investment up to 51%. This is contemplating that 800 crores for which SIA approval was sought for. This is part of that policy. That this is a declaration which was supposed to be given in pursuance of that application for 800 crores. 800 crores to be brought in, out of which 420 crores worth of new capital machinery was to be imported, the scheme, which was not followed. Part of the scheme, clause 3. Clause 3, clause 4, the foreign investment of the same page.
No, that he has read. We are asking your reply. What do you have to say?
I'm saying
you are reading.
I'm saying this is not applicable.
So what is applicable? Show us. Why do you want to again read everything which he has read?
What is applicable is the.
Show us what is applicable. You why SIA that when they say that you have not taken into consideration.
Yes.
The conditions which were applicable.
Yes, what is applicable I have annexed. What is applicable?
Show us what is applicable according to
an export policy.
Yes, show us.
Finally, that is there. That is there, which Reserve Bank has relied upon in its order, page 43 to 50. Extract from the export and import policy from 1st April 92 to 31st March 97, during which the goods came. That is page 43 to 50.
So what is the provision regarding second-hand capital?
What is capital goods is defined. Page 46. First, the definition of capital goods. Capital goods means, as your lordship got that, 46. It starts from,
This is the same policy, sir. This is not a different policy.
No, same policy, but I am just showing that the import of second-hand goods is permissible under this.
Yes, at page 49, this has been read.
Yes, that's what I am relying upon. That's what Reserve Bank has relied upon.
So
because this is what is applicable.
This is not different. You said you are relying on something. No, this is different. This is the same.
This is the policy which is applicable for importation of second-hand capital.
That is what they have relied upon also. This is not different.
Yes,
you said you have relied on something else. No, you have not relied on something else.
That is relied upon by Reserve Bank of India.
Yes,
it is. Definition of capital goods.
It is one and the same. Capital goods is not relevant. Page 49 is relevant. All second-hand capital goods.
Yes, 49 is import of second-hand capital.
So you are relying upon the same thing.
Yes.
And then you also refer to that letter.
Yes, that is also.
So this is your stand.
Yes.
Yes. And what is the date of that letter that you have referred to?
That letter I have annexed the last annexure, 3/1/1994, page 51. Your lordship will get that.
Very well. Yes, so this is your stand.
Yes. This letter has been referred to in our affidavit with Mr. Mukherjee.
That he has already placed that. So this is how you justify the grant of permission.
What my submission, kindly, my lord, bear with me. I'll have a look at it. I'll come back for 5 minutes. This new equipment thing which Mr. Mukherjee is repeatedly referring to.
What is the stand in your affidavit?
Affidavit
relies on this letter.
I'm only I'm not. I'm only trying to submit that this is the policy governing the direct import of second-hand equipment.
Right.
That is the stand of Reserve Bank of India. And so far as this was not handed over, kindly bear with me on this. So far as this letter which was handed over, what does this letter say? This letter says if you bring in second-hand machinery from the foreign exchange point of view, you will not be allowed to repatriate your dividend. The money will remain within the country. My respectful submission is this permission has been given by Reserve Bank of India from the foreign exchange point of view. Now, nobody, Mr. Mukherjee's client, not the company, can be prejudiced if the money remains within the country. He is not allowed to. So even if it's not given, there's no violation of natural justice, or the question does not arise. It's not prejudicial to neither the company nor any of its directors if the money remains within the company.
Very well.
My Lord,
Any judgment?
this judgment again has been referred to, but I am relying on one paragraph which has not been referred
Of which judgment?
Escorts, LIC.
Then don't give us again. Tell us which paragraph.
Paragraph 62. May I place the relevant portion?
Yes, please.
The permission granted by Reserve Bank of India under Section 29 was under challenge. Here, the judgment explained what is the role of Reserve Bank vis-a-vis what is the scope of Foreign Exchange Regulation Act and what is the role of Reserve Bank. Paragraph 63. I beg your pardon, my lord. Paragraph 63. I start from the last line in page 330. The object of Foreign Exchange Regulation Act. May I just briefly place? Object of Foreign Exchange Regulation Act, as explained by us, undoubtedly to earn, conserve, regulate, and store foreign exchange. The entire scheme of design of the Act is directed towards that. Originally, the Foreign Exchange Regulation Act was enacted as a temporary measure, but it was placed permanently on the statute by the amendment extension. The statement of objection discusses. Then, a few lines thereafter, the Foreign Exchange Regulation Act is therefore clearly a statute enacted in the national and economic interest. When considering the statutes enacted in national interest, we have necessarily to take the broad factual situation contemplated by the Act and interpret in provisions so as to advance and not for the particular national interest advancement by the legislation. Traditional norms of statutory interpretation must be broader notions of national interest. If the legislation is from that perspective, as indeed it is imperative that we do so, we find that no difficulty in interpreting permission on subsequent, and we find no justification.
Yes, to conserve, earn, and regulate the foreign exchange. That we have seen. Now what?
Now that is from that angle, Reserve Bank's order has to be construed. I'm only saying that.
That we have understood.
And the other paragraph which I want to rely is 84, which has already been placed by Mr. Mitra and Mr.
That you are the only authority.
No, not that. I am saying this is not a case. My respectful submission that Reserve Bank has acted bona fide following the policy which I have just shown, and there's no malafide intention or there's no non-application in mind, and your lordship may be pleased to, your lordship has vast powers, you can always set aside. In this fact, will not set aside the order.
Very
that, and the last judgment which I want to tie upon is on that issue. Just give me. This is
Yes.
regarding non-furnishing of that order. That
Hmm?
They had taken a point before the lower court as well as here that I have not furnished that letter which I have annexed.
Yes.
I am saying that is not causing any prejudice.
Yes, that you have
So,
said.
so on this aspect, on this point, para 83.
Therefore, natural justice is not a
Yes.
straitjacket formula to be applied everywhere.
Yes.
Only in the case of a prejudice,
Yes,
the right can be claimed.
I'm obliged. Hey,
Yes.
para 83.
Para?
Para 83. Para 83.
Well taken.
So my respectful submission
You
is
have
that
got your submission. You have discharged your duty bona fide. You have looked at the issue with the angle of conservation and regulation of foreign exchange.
and
And as per the policy, including the letter,
Yes.
you have done it. There is no question of any prejudice in this object and therefore not supplied maybe beforehand. And since it was in existence, the power was there anyway, whether supplied or not supplied.
I'm grateful.
Yes. Mr. Mitra.